Karen Thomas presiding.
Have a seat, everyone. Oh, good morning.
Good morning, Your Honor.
Good morning, good morning. My name is Karen Thomas. I am a district judge in Campbell County, so just across the wide-looking river that we crossed to come between the counties. It is my pleasure to be here today to be the judge for the championship round of the Kentucky High School mock trial tournament. I've been involved with the Kentucky High School mock trial tournament for years. I started on the bench in '96, and I think my first experience with the mock trial process was in '97. And I have enjoyed every time I've ever been involved in the process. I run a team court for Northern Kentucky, so I certainly understand how amazing all of you are and how amazing your parents and supporters are for all the time and effort they've spent traveling all over Kentucky, right, to get here today. We have had apparently 40 teams, or over 40 teams, that participated in the tournament this year, and we're down to 2, right? And we're going to have our championship round start today. Oh, I do have to mention that the Kentucky Bar Association is in large part to thank for the process, right? It's partly funded the grant that runs or enables this program to go forward. So I know we all appreciate that and appreciate the Kentucky Bar Association for doing what they did. I'd like to ask, before we start, a couple of things. First of all, no cell phones should be on, right? So if you have a cell phone, it's okay, but turn it off, right? Make sure it's turned off. We just don't want to disrupt the counsel while they're presenting their evidence, or the jurors. We don't want to take away from them. For any reason you need to leave during a round, please go ahead, take a break. If you're in the courtroom, you can come and go. If you're attorneys and participants in the process, jurors, if for any reason you're unable to wait until we take a break, we're going to take a quick we started late, right? So we're going to take a quick 5-minute break between the cases in chief, between the plaintiff and the defendant, but only 5. So that's time to go to the restroom and get some water and leave, but not a lot. If you can hold off until then, great. If not, let me know. We can take a quick break to accommodate you. I don't want anybody uncomfortable. Of course, please try to always ask for a break if you need one at a conclusion of testimony if it's at all possible. So it's least disruptive. All right, what we're going to do today is we're going to start with our case. Our case is Justin Burke versus Forensic Tech Inc. It is a matter of a civil lawsuit alleging gross negligence. I want to see if everybody is ready to proceed. Is the plaintiff ready to proceed?
Yes, Your Honor. Before we begin, would you like a copy of our roster and pre-stipulated documents?
I would. Good morning. Thank you. Thank you. Thank you very much. Defense, are you ready to proceed?
Yes, Your Honor. Would you like a copy of our roster as well?
I would.
And may I approach the bench?
You may. Thank you, ladies. Now, are there any preliminary matters that need to be dealt with, plaintiff?
Yes, Your Honor. At this time, may we begin with introductions?
Absolutely.
My name is Julia Hughes. I will be directing Dr. Nikki Chantal, crossing Dr. Madison Roper, as well as giving the closing argument.
Good morning, Your Honor. My name is Josie Montfort. I'll be delivering opening statements, directing Sydney Burke, and crossing River Forest.
Good morning, Your Honor. My name is Mara Shute. I will be directing Dakota Piper, as well as crossing Dr. Hayden Woodward.
Good morning, Your Honor. My name is Natalie Gertis, and I will be portraying the role of Sydney Burke, the mother.
Good morning, Your Honor. My name is Kathleen Crow, and I will be portraying the role of Dakota Piper.
Good morning, Your Honor. My name is Brianna Seibert, and I'll be portraying the role of Dr. Nikki Chantal.
Thank you, ladies.
That concludes our introductions. We have a few housekeeping matters. May we address those at this time?
Absolutely.
Do we have permission to move freely about the well of the courtroom while respecting the distance to the witness and the bench?
Absolutely.
May we assume that the judges in the jury box are members of the jury?
You may.
Would you like for us to state the basis of our objections immediately or wait until called upon by your honor?
I would like you to state them immediately.
For purposes of this trial, may we give evidence being entered to the scoring judges of the jury?
You may.
At this time, Your Honor, we invite the court to take judicial notice of motion number 6 found in the orders on motion in limine, which states that although today's case is a bifurcated trial, the court notes that evidence related to damages may still be admissible during the liability phase if such evidence is relevant to prove or disprove other elements of the plaintiff's claim. Element number 4 of our claim today is damages. We must prove this in order to prove gross negligence. According to Utopia's Civil Code, damages refer to any past, present, or future pain and suffering.
All right. It's noted.
We'd also invite the court to take judicial notice of stipulation number 5, which states, due to the extent of his injuries and his lack of memory regarding the events in question, Justin Burke is unable to be deposed or to testify in these trial proceedings.
And that's a stipulation between you and defense counsel, correct?
Yes, Your Honor.
Okay, it's noted.
At this time, Your Honor, the plaintiff is ready to proceed.
Thank you, ma'am. Defense, do you have any preliminary matters in your introduction?
Yes, Your Honor. May we proceed with introductions first?
Absolutely.
Good morning, Your Honor, members of the jury. My name is Sydney Skaggs, and I, along with my co-counsel, Ms. Alyssa Bosley,
Good morning, Your Honor, members of the jury.
and Mr. Brendan Riesenbeck,
Good morning, Your Honor, members of the jury.
will be representing the defendant, Forensitech Incorporated, in today's case. Our witnesses today are
Good morning, Your Honor, members of the jury. My name is Catherine Kramer, and I will be portraying the role of Dr. Hayden Woodward.
Good morning, Your Honor, members of the jury. My name is Nia Phelps, and I'll be portraying the role of Dr. Madison Roper.
Good morning, Your Honor, members of the jury. My name is Davis West, and I'll be portraying the role of River Forest.
Thank you very much, gentlemen and ladies. Any preliminary matters, ma'am?
Yes, Your Honor. First, I'd like to clarify something from the plaintiff's pretrial matters. Under the 6th order on motions in limine for bifurcation of today's trial, any evidence solely relevant to proving or disproving damages is excluded. If it goes to another element of the case, not damages, it is admissible, but any evidence solely relevant for damages is not admissible, as damages is separated from the liability phase in today's case.
This is a bifurcated hearing, correct, between liability and damages?
Yes, Your Honor.
So we have to prove, what do you have to prove when you have liability?
Duty, a breach of duty, causation, and damages.
So you have to prove damages in order to prove liability?
Yes, Your Honor, but the question of liability is separated from the question of damages under the 6th order in motions in limine.
But you just told me in order to prove liability, you have to prove damages.
Yes, Your Honor.
Okay. So I tell you what we'll do. I understand your process and I understand what you're saying. The extent to any damages in terms of monetary loss associated with those damages certainly is inadmissible in a liability trial. The indication of whether or not the young gentleman suffered any sort of loss, pain, suffering, damages, illness, whatever, is admissible, I think, towards that 4th prong of gross negligence. But only as to that's what happened, not to the extent of the damages or the amount of the loss.
Yes, Your Honor.
Right? Okay. Thank you, ma'am.
And we also have another pretrial matter to discuss. We would like the court to take judicial notice of stipulation 2, in which, in accordance with this stipulation, both parties have waived any and all objections. The exhibit to the liability and registration form for Forensitech Incorporated.
So,
and Your Honor, pursuant to mock trial rules of competition, witnesses can be sworn in one of 2 ways. Would you like that we assume witnesses have collectively been sworn in, or would you like to swear them in before testimony?
I will assume that everyone has been appropriately sworn.
Yes, Your Honor. And with that, the defense is ready to proceed.
Thank you, ma'am. All right. I think we are ready then for openings. Plaintiff.
Yes, Your Honor. May I proceed?
Certainly, ma'am.
May it please the court, opposing counsel, members of the jury. Good morning. My name is Josie Montfort, and I, along with my co-counsel, Julia Hughes and Mara Shute, have the honor and privilege of representing the plaintiff, Ms. Cindy Burke, and her son Justin in today's proceedings. Members of the jury, Forensitech failed to follow protocol, which is what caused Justin Burke to fall. Before June 28, 2018, Justin Burke was an intelligent and driven young man with dreams of becoming a forensic analyst. Now, he is a quadriplegic that will likely never be able to fulfill those dreams that he had been planning on for his entire life. Members of the jury, although unfortunate, it is important to note today that Forensitech's breach is what caused Justin Burke's injuries and is the reason why we are here today. Justin Burke's life is forever changed. Members of the jury, today the plaintiff holds the burden of proof. This means that we must prove to you by preponderance of the evidence, which is just a slight tip of the scales in our favor, that Forensitech was grossly negligent. How will we do this? We will show you that Forensitech's completely avoidable actions show a reckless disregard for Justin Burke's safety. Forensitech owed Justin Burke a duty to exercise ordinary care. Forensitech breached this duty of care by choosing to ignore national guidelines that would have ensured Justin's safety while he was at camp. Forensitech's breach is the reason why we are here today and is the reason why Justin Burke was injured. Today, we're going to present to you the 4 elements of negligence. First, Forensitech had a duty to care for Justin. Second, Forensitech breached this duty of care by failing to uphold National Camp Association guidelines. Third, Forensitech's breach is both actual and proximate cause of Justin Burke's injuries. And finally, the injuries that Justin Burke sustained were so severe that he now is quadriplegic. Members of the jury, the plaintiff is not here today to tell you how Forensitech was negligent. We are here to show you that their completely avoidable actions show a reckless disregard for Justin Burke's safety that was so severe that it caused a substantial and unjustifiable act of harm against Justin Burke. Members of the jury, today the plaintiff is going to call to the stand 3 witnesses that will all testify to the clear violation of National Camp Association guidelines and to the clear failure to follow protocol. Today, you're going to hear from Ms. Cindy Burke. Cindy Burke is Justin Burke's mother, and she is going to testify to you today that her son did have diabetes, but he managed it extremely well. She is going to testify to you today that Forensitech ruined her and her son's life forever. Next, you're going to hear from Ms. Dakota Piper. Dakota Piper is Justin Burke's very best friend. She is going to testify to you today that her and Justin had been planning on becoming forensic analysts together for their entire lives. She is going to testify today that Forensitech took the future that they had been planning on and ruined it. And finally, you're going to hear from Dr. Nikki Chantal. Dr. Chantal is an emergency room physician who is going to provide to you today details of emergency medicine that were put into use in the early morning hours that Justin Burke was rushed into the ER. Members of the jury, Forensitech failed to follow protocol, which is what caused Justin Burke to fall. Forensitech failed to follow protocol by allowing River Forest, a young counselor, to take even younger campers on a hike to a location she had never been to before. Justin Burke was an intelligent and driven young man on the pathway to becoming an extremely successful forensic analyst. Now, members of the jury, he can barely move from the neck down. Find Forensitech liable of gross negligence and of the injuries of Justin Burke, because that is the only verdict today that the law requires, the facts compel, and justice demands. Thank you.
Thank you, ma'am. Vince,
Your Honor, before we proceed with opening statements, we do have a note for the record. Pursuant to the mock trial rules of competition, we are not allowed to object during opening and closing statements under Rule 4.18. However, we are allowed to note afterwards if the would have been an objection during opening statements.
Okay.
Um,
Do you have such a notation you'd like to make?
Yes, Your Honor. We
What
would
is
have
that?
objected to the statements Forensic failed to follow protocol which caused Justin Burke's injuries, and Forensic's breach is why we're here today and is why Justin is injured as argumentative, which is outside the scope of an opening statement, Your Honor.
Okay. Well, she did say we will show, and I think that stops the argumentative nature of her statement. If she had said, as a fact, I think that you were right, bordered on argumentative, but I think she was okay. So I would overrule your objection if you had noted it.
Yes, Your Honor.
All right. Ma'am, are you ready to proceed?
Yes, Your Honor. We're ready to
Oh,
proceed
sir,
with
I'm
opening
sorry.
statements.
May I proceed?
Absolutely.
May it please the court, opposing counsel, members of the jury. What the plaintiff failed to mention is that a key piece of medical information was withheld from my client, Forensic. The plaintiffs, the Burkes, were asked numerous times to disclose any medical conditions Justin had prior to his arrival at camp. They were asked this on the application and upon Justin's arrival the first day at camp. But the Burkes kept it a secret. They knowingly withheld information that Justin Burke was a type 1 diabetic. It was this secret that prevented camp staff from knowing that Justin could become incoherent or confused to the point where he was a danger unto himself. It was this secret that thwarted camp counselors and medical personnel alike from being able to properly cater to the safety needs of Justin Burke. Because, ladies and gentlemen, secrecy is the enemy of safety. This is Dr. Hayden Woodward, former medical examiner and forensic scientist who is now the current owner and CEO of Forensic. Dr. Woodward and her company provide jobs as camp counselors, nurses, and forensic instructors. Forensic Tech camps are a part of the Utopia School of Science and Technology. Forensic Tech Inc. is a company that provides summer camps for youth interested in pursuing careers in forensic science. Forensic Tech camps are incredibly well organized and well staffed. Now, throughout the course of this trial, there are a couple of legal terms you will need to understand. The first is the difference between negligence and gross negligence. Negligence simply requires proof that there was a breaching of a duty of care. Gross negligence requires proof that there was a reckless disregard for the lives of others. In today's case, the plaintiff alleges that Forensic Tech was grossly negligent in the operation of its summer camp. To disprove this, we will call upon three witnesses. First, we will call upon Dr. Hayden Woodward, who will testify that zip-zero, no medical documentation was provided to Forensic Tech indicating that Justin was a type 1 diabetic. Second, you will hear from Dr. Madison Roper, Justin's treating physician, who will testify that she had personally recommended that Justin wear a medical ID necklace that in the event of an accident would allow medical personnel to identify Justin as a type 1 diabetic and apply proper care. And lastly, we will call upon Camp Counselor River Forest, who despite being the staff member responsible for Justin's safety, will be joining others in testifying that Justin's diabetes was unknown to him. Ladies and gentlemen, this case is simple. Throughout the course of this trial, it is crucial that you separate feeling from fact and suspicion from proof. And in doing so, what you'll find is that in so swiftly filing a suit against Forensic Tech, they failed to take responsibility for their own secret. And that secret became the true enemy of Justin Burke's own safety. Find Forensic Tech not liable. Thank you.
Thank you, sir. Plaintiff, call your first witness, please.
Yes, Your Honor. At this time, the plaintiff calls Dakota Piper to the stand.
Piper, you've previously been sworn, ma'am. If you'd have a seat in the witness box, please.
May I proceed, Your Honor?
Absolutely.
Can you please state your name and spell your last for the record?
Dakota Piper, Piper.
Can you tell me a little bit about yourself?
I'm 16 years old. I went to Jordan River High School in Utopia City with my best friend Justin Burke, and we plan to go to the same college.
Now, what college did you guys plan to attend?
We planned to attend Utopia University, where we would double major in chemistry and forensic science.
You said planned in the past tense. Are you not going there anymore?
Well, we probably won't be able to go there anymore as Justin is now a quadriplegic. You should have never gone on to that stupid camp.
Can you explain to me what camp you're talking about?
Well, Justin was going to go to Utopia School of Science and Technology, or USST, for his final 2 years of high school, and he learned about forensic tech camp, so we thought it would be fun if we decided to go together, so we did.
How was your camp experience?
At first it was great. We both got into the DNA analysis group, which was the group that at least I wanted to be in.
What did you do at this camp exactly?
Well, the camp set up a mock crime scene kind of, where you had different pieces of evidence, and then at the end you had to come forward with who you thought the criminal was. But then we also got to attend different lectures by different types of forensic scientists, MEs, and professors at Eaton University.
Now, were these the only things you got to do at the camp, or were there other activities?
No, we got to do other activities too. Like, there was one Sunday night when we went on a scavenger hunt of the whole camp, just to kind of try to find a way around a little bit better. And the winning team would get a pizza party, which River seemed to have a good sense of direction around the camp, and he showed us some shortcuts, so we ended up winning by a lot.
You mentioned someone named River. Who is that?
River was our camp counselor, and I really liked him at first too, so it just makes what happened on the hike that more sad.
Can you please explain what hike you're talking about?
Well, River's friend informed him about this hike to this waterfall, so River told us that he thought it would be fun, so we decided to go on this hike. But River told us that he had never been on that specific hike, and so when we were supposed to go though, River's friend could no longer go on the hike with us.
So, if River's friend hadn't been, River's friend could no longer go and River hadn't been, did you guys still end up going?
Yes, we still went on the hike, and at the time I just figured that River and Forensic Tech probably had it all under control, but looking back, I now realize that I was very wrong.
What do you mean you were wrong?
Well, we thought we'd hike to this waterfall and it would be 10 to 15 minutes and then we'd have a picnic, so the whole day would be about 3 hours, but that is not what ended up happening.
Can you please explain what did end up happening then?
What was supposed to be a 3-hour hike turned into a 13-hour nightmare.
Now, can you please explain what you mean by nightmare?
Well, we started out on the hike and we were having a good time jumping through streams and everything, but then it started getting darker and I looked at my watch and realized that an hour had passed and we were supposed to reach this waterfall in 10 to 15 minutes. So I informed River of this, and River told me that he didn't know that this hour had passed and we were going to turn back, but River said that he didn't even know how we got to where we were.
So why didn't you guys just call for help then?
Well, we would have, but River said his phone was dead. Even if it wasn't, we couldn't get any cell signal. But River told us that maybe if we climbed to a higher elevation, we could get some cell signal. And maybe if we did, we could wait for help there. So we did do that.
Now, were you able to get cell signal at this higher elevation?
Yes, but only if the River and another student climbed even higher up the cliff. But River did inform us that help was supposed to be on the way.
Did help ever come?
Well, help came, but by the time they were there, it was too late.
What do you mean it was too late?
Well, it started getting darker and colder, and it even started raining, so River decided that we would stay on the cliff and wait for help there. So we kind of just had to dig in that we were literally on the side of a cliff. I mean, there was not a lot of flat ground. If you wanted to walk, you had to walk single file, and I saw 2 girls almost slip down the cliff because it was so slippery. And we took turns yelling for help so that if help was anywhere out there, maybe they could find us. And if you had to go to the restroom or anything like that, we used the buddy system. But eventually we all got tired and we went to sleep. That is until around 3 in the morning when Justin woke me up.
Why did Justin wake you up?
Justin woke me up because he said he had to use the restroom, but it was 3 in the morning, so I didn't really want to get up to go with him. But just as I was about to, I heard him scream.
What happened next?
My heart just sunk, and then River woke up and we both rushed to the bottom of the cliff, and we found Justin laying in a cold stream crying that he couldn't feel his legs.
How did you react?
I mean, I was terrified. He was my best friend in the entire world, and he had just fallen from a cliff. And then River informed me that we had to move Justin out of the stream, but I didn't know how to move someone who was probably pretty injured.
Where did you guys move him to?
We moved Justin to a flat surface outside the stream, but it was so dark we had to use our feet to try to find where the flat surface was. And on the way there, River almost dropped him.
Now, what did you do after you moved Justin to this flat surface?
Well, we just sat with Justin and tried to keep him awake and calm until help would come.
When did help come?
Help came several hours later, and those were some of the longest hours of my entire life, but they did take Justin away, and he was on his way to the hospital around 7:30 in the morning.
Now, Dakota, how is your and Justin's relationship today?
Justin and I's relationship, we were best friends, and I believe that because Forensic Tech ignored protocol, that's what caused Justin to fall, and now our friendship and our futures will forever be altered.
No further questions at this time, Your Honor.
Thank you, ma'am. Cross?
Yes, Your Honor. May I proceed?
Yes.
You are Justin Burke's best friend.
Yes, we've been best friends since middle school.
Justin would eat dinner with your family several times a week at your house.
Objection, Your Honor. Relevance.
Your Honor, I'm just trying to prove the closeness of the relationship between Dakota Piper and Justin Burke.
It's valid. Overruled.
Yes, Your Honor.
And Justin never told you he was a type 1 diabetic.
No, Justin didn't tell me he was a diabetic, and I guess I can understand why, because in the past he had been bullied and teased a little bit, so I can assume that maybe he just didn't want other people to judge him and treat him as disabled.
Justin was keeping a secret from you.
Objection, Your Honor. Speculation.
Overruled. She just testified to it.
Justin was keeping a secret from you.
Is that a question?
Yes.
I guess Justin had kept the secret that he was a diabetic from me, yes, but I mean, most people keep secrets, and as I said, I'm sure he just didn't want people to see him as being disabled or see him in a negative light.
For whatever reason, Justin was keeping a secret from you.
Yes, Justin had kept the secret from me.
Before you arrived at camp, you had to fill out a medical release form.
Yes, we did.
You listed asthma as a condition on this form.
Yes, I've had asthma for some time now, since I was little, and it's kind of just been a part of my life for almost as long as I can remember.
And upon your arrival at camp, you were given a chance to review this application form.
Yes, they handed them back, and Justin and I just handed them to my parents who had driven us there.
Now, I want to shift focus to the hike. Before you left on the hike, you noticed River had packed up picnic supplies and bottled waters.
Yes, River did pack up those things, and then he left them in the van and figured we'd come back for them after we had reached the waterfall.
And during the course of the hike, several students expressed they were hungry.
Yes, after we had realized that we were lost, some of the students did say they were hungry.
And in response, your camp counselor, River Forest, handed out granola bars and instructed all the students to share water.
Yes, River didn't actually bring water, so we had to share with the other students, but River did give out some granola bars.
And you don't recollect seeing Justin eat or drink anything?
I didn't physically see Justin eat a granola bar, but I wasn't constantly watching or wasn't constantly with Justin, so for all I know, he could have taken a granola bar from River when I just wasn't looking.
As far as your knowledge goes, you don't recollect seeing Justin Burke eat or drink anything during the course of the entire hike?
Yes, I don't remember seeing him eat a granola bar, but I wasn't with him at all times, once again.
Around 3 a.m., Justin woke you up.
Yes.
He seemed confused.
Justin did seem a little groggy because, I just figured that it was 3 in the morning and he could have just woken up from a deep sleep, and people are usually kind of confused or groggy when they first wake up.
He said, "Where are we? What's going on? Why does my head hurt?"
Objection, Your Honor. Hearsay.
Your Honor, in accordance with Rule 801D2, these are statements made by an opposing party.
Your Honor, may I amend my objection to compound question then?
Overruled. It's all part and parcel. You may redirect and clarify if it's needed. Go ahead.
His words were, "Where are we? What's going on? Why does my head hurt?"
Yes, Justin did ask those things, and I was just kind of like, Justin, we're at the camp, and I just figured that it was because he had just woken up from this deep sleep.
And you told him, "We were lost in the woods on a hike for camp."
Yes, that's what I told him because we were lost in the woods.
And Justin replied, "Camp?" like he didn't know what you meant.
Yeah, Justin did say that, and once again, everyone is usually pretty groggy when they first wake up, so I just figured that that's what the cause was and that he wasn't fully awake yet.
And you told him to go back to sleep.
Yeah, I did tell him to go back to sleep because it was 3 in the morning and it was really dark. It was cold, it was wet, so we had just gotten lost on this hike and I was very exhausted, so I just told him to go back to bed.
And then Justin, the type 1 diabetic, confused, exited the tent without you, and then slipped and fell down the hillside.
I am not sure if this is why Justin slipped down the hillside. Yes, he was a type 1 diabetic. He could have slipped down the hillside from being slippery, as 2 other girls almost slipped down this hillside too. I'm not sure. I'm no doctor. I don't know if that's why Justin fell down the hill.
He exited the lean-to in a state of confusion without you, and then slipped and fell down the hillside.
Objection, Your Honor. Asked and answered.
Overruled. He asked it a different way this time. Go ahead. Witness may answer.
Yes, that's what happened.
No further questions.
Thank you. Redirect.
Yes, Your Honor. May I proceed?
Of course.
Dakota, from what you saw, what supplies did River have?
From what I saw, River had a backpack, and inside that backpack, I guess, were some granola bars. As I said, River didn't even bring water, so we had to share once we got lost. Also, River told us that his phone was dead, so I don't know if it was fully charged when we began or not, and I didn't see River with a GPS or a compass. Seemed kind of like River was unprepared, if you ask me.
No further questions at this time.
Thank you, ma'am. Recross.
Yes, Your Honor. In response to students being hungry and struggling, River handed out granola bars and instructed the students to share water.
Yes, River did hand out some granola bars.
No further questions.
Thank you. Ma'am, you may step down. Call your next witness.
Yes, Your Honor. At this time, the plaintiff calls Dr. Nikki Chantal to the stand.
Ma'am, you've previously been sworn. You're under oath. If you take a seat.
Yes, Your Honor.
Thank you.
May I proceed?
Absolutely.
Hello, Dr. Chantal. Please state your name for the judge and the jury.
My name is Nikki Chantal, Chantal.
And why are you here today, Dr. Chantal?
I'm here to testify about Justin Burke and the injuries he sustained on June 28th of 2018, which I later examined.
Now, before we get into your conclusions, I'd like to talk a little bit about your qualifications. Can you give us an overview of your education?
Yes, I went to the University of New Caesarea. From there, I went to Harvard Medical School, and I finished up my residency in emergency medicine at Johns Hopkins.
What is your work experience?
For the past 17 years, I've been working at Garden County Medical Center as an ER doctor. I'm now the chair at Garden County Medical Center, and I'm also a professor.
Have you ever appeared in court before as an expert?
Yes, due to my line of work, I've testified on 5 other previous occasions, solely on the injuries prior to my patients reaching our nationally acclaimed hospital.
I'm sure you aren't doing this all for free. Are you being compensated for your work?
I am being paid to give my time and my expertise.
Dr. Chantal, will your specialized knowledge in emergency medicine help the judge and the jury come to a decision in today's case?
I believe so.
Is your testimony today based on sufficient facts and data?
Yes.
Are the principles and methods you used in coming to your conclusion reasonably relied upon in your field of study?
Yes.
And have you applied those principles and methods reasonably in today's case?
Yes.
Are all the opinions you are about to give based on a reasonable degree of scientific certainty and probability?
Yes.
At this time, Your Honor, the plaintiff moves to tender Dr. Nikki Chantal as an expert in emergency medicine.
Any objection, counsel?
No, Your Honor.
All right, noted, she's an expert.
Okay, Dr. Chantal, what state was Justin in when he entered the ER on June 28, 2018?
Justin came in the ER around 7:58 a.m. He was brought in on a backboard with his head and neck immobilized and a semi-rigid cervical collar.
What did you do from there?
Well, the EMTs had called ahead of time, so I was aware that Justin was on his way. So when he came in, I began preparing him for the intensive care unit, also known as the ICU. And while I was preparing Justin, the EMT had given me a quick report.
What was the first step you took to prepare Justin for the ICU?
We began evaluating Justin by using the ABCDE protocol.
Can you walk us through your evaluation of Justin using this protocol?
Yes, so A stands for airway. Justin's airway was not obstructed. B stands for breathing. His breathing was a little shallow, so we put him on oxygen to bring it back up to adequate levels. C stands for circulation. His pulse was a little decreased, but it wasn't due to any internal or external bleeding. D stands for disability and neurologic status, and he was suffering from neurogenic shock due to his spinal cord injury.
What did you do after evaluating Justin with the ABCDE protocol?
While Justin was in the hospital, we kept his head and neck completely immobilized. And Justin also remained very unresponsive to our questions. He seemed a little groggy and out of it. But we still conducted motor and sensor evaluations, which revealed that Justin was unable to move his lower limbs. But once he was stabilized, we took him to get computerized tomography scans, also known as CT scans.
And what did these CT scans reveal?
Justin had broken his neck due to a fall, and he also suffered from an incomplete spinal cord injury at the C6 vertebrae.
What is an incomplete spinal cord injury?
Basically, an incomplete spinal cord injury is wherever that injury may be on a patient, the function below that injury may be unaffected.
Well, how did this play out in Justin's case?
For Justin, he suffered severe compression and partial lesion on his spine at the C6 vertebrae, which rendered him a partial quadriplegic.
What is a quadriplegic?
It's an individual who has minimal to no control over his arms, legs, or his torso.
Did Justin appear to have sustained any other injuries?
Justin appeared to have a concussion. I'm not to his fogginess and not understanding our questions, but we decided to take care of his concussion in follow-up care.
Going back, Dr. Chantal, what happened once Justin was ready to be admitted to the ICU?
He underwent decompression and spinal fusion surgery within the 12 hours of admission so we could prevent further injury.
And how long did he have to stay in the hospital?
He was in the ICU for about 3 days and the hospital for nearly 3 weeks until he could be moved to a rehab facility near his home.
Are there any updates on how Justin's injuries have progressed?
He has a little bit more movement in his wrists and his fingers, but that's unlikely to change even with intensive rehab.
What about the possible concussion? Was that ever updated?
Yes, his concussion manifested in symptoms of headaches, memory problems, and just mental fogginess.
Moving on, Dr. Chantal, were you ever able to get any information from Justin about what happened on that fateful day?
Due to the fact that Justin was mentally just really confused, he was unable to tell us the series of events on the day of the incident and any of his time in recovery. But I did get some information from the EMT, which he had obtained from the camp counselor.
What did the EMT report?
He reported that the camp counselor had informed him by the time he reached Justin at the bottom of the cliff, Justin was already unable to move. And a camp counselor, along with another camper, had moved Justin.
Could this movement have caused any further injury?
Yes, anyone with a spinal cord injury should not be moved if at all possible. I was informed that the camp counselor had supported Justin's neck during the move, but I know as an American Red Cross and Wilderness instructor, I know moving Justin was not without risk.
Moving on, Dr. Chantal, what does Justin's life look like after this incident?
Justin may be able to work a motorized wheelchair, but beyond that, he's going to need help with daily living, feeding, dressing, toileting, bathing, and on top of that, Justin has diabetes. Someone's going to have to help him administer insulin and keep a basic, you could call it a diabetic diary. And since we decided to treat Justin's concussion and follow-up care because his spinal cord injury was so severe, his brain never was able to heal properly, but hopefully over time, his concussion will heal.
Aside from physical impairments, what does Justin's future hold?
Justin will be very unlikely to attend college, or at least
Objection, Your Honor. Under Judge Ridgway's 6th order of motion in limine, this case has been bifurcated, and Justin's inability to attend college in the future or Justin's future quality of life is therefore inadmissible.
May I respond? Your Honor, one of the 4 elements we must prove today is damages, which refer to any past, present, or future suffering. Justin's inability to go to college is to be considered future suffering, considering he had dreams of becoming a forensic analyst.
I'm going to sustain the objection. Move on, counsel.
Yes, Your Honor.
May I move to strike this part of the testimony?
You may. The jury shall disregard the prior testimony of the witness.
Yes, Your Honor.
Dr. Chantal, in your expert opinion, if River had just followed protocol, would Justin's life be different today?
Objection, Your Honor. In accordance with Rule 602, this witness has no personal knowledge of River or any actions River Forest took.
May I respond? Your Honor, as an expert witness, Dr. Chantal is qualified to testify to the ultimate issue.
May I respond, Your Honor? Your Honor, I'm not objecting to ultimate issue. I'm objecting to a lack of personal knowledge under Rule 602. Information about what River did is outside the scope of this witness's knowledge. Not only was Dr. Chantal not there, they didn't review any witness affidavits, so they would have no way of knowing anything about River Forest's actions.
May I respond? In coming to her expert conclusion, Dr. Chantal relied upon the report that the EMT gave her. Therefore, she has knowledge of River Forest's actions.
I'm going to sustain the objection.
Yes, Your Honor.
Yes, Your Honor.
You certainly may lay the foundation for asking that question, but so far you have not.
Yes, Your Honor. Move to strike this testimony.
Jury shall disregard.
Yes, Your Honor.
Dr. Chantal, how do you know about what occurred on the hike?
I drew my expert opinions due to the EMT report that I received.
And from that EMT report, can you conclude whether or not Justin's life would be different?
Objection, Your Honor. This witness is testifying to facts, not evidence.
She's also testifying, she is also asking a question as to liability. I've already stopped you from that, counsel.
Yes,
So
Your
I'm going to sustain the objection.
Yes,
No
Your
further issues as to liability, please.
Yes, Your Honor.
Thank you.
Dr. Chantal, is Justin's life different after this incident?
Yes, I believe so.
Are all the opinions you just gave based on a reasonable degree of scientific certainty and probability?
Yes.
No further questions at this time, Your Honor.
Thank you, counsel. Cross.
Yes, Your Honor. May I proceed?
You may. Go ahead.
Now, Dr. Chantal, I'd like to begin by discussing something you mentioned on cross. You are on direct. You do not blame River Forest for moving Justin out of the stream, correct?
I do not blame River, although the move could have caused further injury.
Now, I'd like to discuss your compensation in today's case. You've testified in court on 5 separate occasions,
Yes, that is true.
and all 5 times have been for the plaintiff.
Those are the plaintiffs, the only one that has called me, and not to mention, due to my line of work, I just happen to be testifying for the plaintiff.
So that's a yes.
Yes.
Now, in today's case, you're being paid $18,000 to testify for the plaintiff,
I'm here to give my time and my expertise.
but you are being paid $18,000?
Yes, I'm being paid to get my time and my expertise, such as they're a medical expert as well.
And for $18,000, you reviewed just 4 exhibits.
For me giving up my time today would just be as if I wasn't in work. I'm not in work right now, so I'm being paid to be here today to give my time, my expertise.
But you did review just 4 exhibits in today's case,
Yes, that is true.
one of these being your own resume.
Yes, that is true, to prove my qualifications.
Now, the documentation you reviewed on which you based your medical opinion did not include any witness affidavits.
I did receive an EMT report, which gave me the actions of River after Justin fell.
But Dr. Chantal, you did not review any witness affidavits?
No.
Now, I'd like to discuss the time frame in which Justin was injured. You're familiar with the ER record of Justin's treatment, correct?
Yes.
And you'd recognize a copy if I were to show it to you here today?
Yes, I would.
Let the record reflect that I'm now showing opposing counsel which has been previously marked as Exhibit 7.
Noted.
This is the one I'll be showing you. Courtesy copy, Your Honor?
Certainly.
May I approach the bench?
Absolutely.
May I approach the witness?
You may, ma'am. Thank you.
Thank you.
Dr. Chantal, this is the emergency room report on the day of Justin's injuries, correct?
Yes, that is correct.
And it's a fair and accurate copy?
It appears to be so.
It hasn't been changed or altered in any way?
No.
Your Honor, at this time, defense moves for the introduction of Exhibit 7 into evidence.
Any objection, counsel?
No, Your Honor.
All right. Then so moved.
Your Honor, at this time, may I publish Exhibit 7 to the jury?
You may.
Now, Dr. Chantal, this ER record contains a treatment summary of Justin Burke, correct?
Yes,
And for clarification, Justin arrived at the hospital at 7:58 a.m.
that is true.
And the treatment summary begins at 8:04 a.m.
Yes,
And at 8:07 a.m., you gave Justin a finger stick blood glucose test.
that is true. His blood sugar level was low. It was at 40.
Exactly. It was 40 milligrams per deciliter, which is 40 milligrams below the minimum normal range.
Yes, that is true.
Now, to combat this, you gave Justin an IV of dextrose.
Yes, we gave him dextrose because he was hypoglycemic. So to give him the dextrose, we would hopefully raise his blood sugar levels.
Dextrose is sugar.
Yes, that is true.
Now, because Justin was diabetic, sugar wasn't what Justin needed.
It is not, but after we got the lab reports back with the blood tests, we found out that Justin in fact did have diabetes. So the dextrose we gave him, he was unable to process because Justin's a diabetic, he's not making insulin. So we combated this by giving Justin insulin, and then we got his blood sugar back under control.
But that's a no. The dextrose you gave Justin was not what Justin needed.
No, Justin needed insulin.
Now, you didn't know Justin was a diabetic, that Justin needed insulin, because Justin was not wearing a medical ID.
No, not that I visually saw.
And as a trained physician, you're trained to look for a medical ID.
Yes, of course, but like I said, we had to run blood tests anyways. It's protocol for every one of my patients that come in.
But that's a no.
I'm sorry, no.
That's a no. Justin was not wearing a medical ID, which you're trained to look for.
Yes, I did not visually see one.
Now, going back to Justin's treatment, the dextrose did not have the intended effect.
No, like I said before, Justin's not making insulin, so it's insulin. He didn't have insulin to move this dextrose, which is a type of sugar, into his cells to be used. So that's why when we took a second blood test, his blood sugar was through the roof. But that's why we gave him insulin to get it back under control.
Exactly. At 8:50 a.m., you gave Justin a second finger stick blood glucose test, which revealed that Justin's glucose levels were high.
Yes, that is true because he could not process the dextrose.
And because of this, you immediately had to change course and give Justin insulin.
It was a minor bump in the road. Our main concern was really the spinal cord injury.
But you would agree with me that hypoglycemia is life-threatening?
Of course.
Now, at 9:25 a.m., Justin's blood glucose levels were finally back to normal.
Yes.
You would agree with me that from Justin's arrival all the way to the time they were back to normal was an hour and a half.
Yes, that is true. But like I said, getting his blood sugar under control was honestly the least of our concerns. His spinal cord injury was really our main concern, and that's why we took him into the ICU to prep him for surgery.
But it was an hour and a half to get Justin back to normal range.
Yes, that is what the timestamp shows.
So you would agree with me that there was a delay in your treatment of Justin.
There was a delay in treating his blood sugar. Yes.
Again, doctor, if a diabetic has extremely low or extremely high blood sugar, they could die, correct?
Objection, Your Honor. Asked and answered.
May I respond, Your Honor? Your Honor, earlier I asked about Justin's hypoglycemia. However, this is pertaining to Justin's glucose levels and Justin's low blood sugar.
I think it's sufficient that she can clarify that where she's going with it. Overruled.
Yes, Your Honor.
Now, if a diabetic were to have extremely low blood sugar, they could die.
Yes, it's possible they could go into a diabetic coma. That's true.
But they could die, correct?
In theory, yes.
Now, I'd like to discuss Justin's symptoms when he arrived at the hospital. When Justin arrived at the hospital, he seemed confused.
He did seem confused, but you also have to remember Justin was suffering from a concussion and also neurogenic shock and hypoglycemia. So we couldn't exactly pinpoint which one of those three things was the exact cause of his confusion.
But you would agree with me that confusion is a symptom of hypoglycemia.
As well as the other things I mentioned, neurogenic shock and a concussion, but yes.
Lack of muscle coordination is also a symptom of hypoglycemia.
Yes, that's true, but he was also paralyzed. He had a spinal cord injury.
Dr. Chantal, I'm asking about Justin's hypoglycemia specifically. Lack of muscle coordination is a symptom of hypoglycemia, correct?
Yes.
Thank you, Your Honor. No further questions at this time.
Thank you, ma'am. Redirect.
Yes, Your Honor. May I proceed? Hello, Dr. Chantal. How much did the few issues with Justin's blood sugar affect his overall treatment?
It was, like I said, it was a very minor bump in the road. The main issue was Justin's spinal cord injury, which that was our main concern. But we got his blood sugar back under control. We went forward with the treatment.
And what is the only way that one can raise a diabetic's hypoglycemia?
It's by giving a patient insulin.
Do you mean dextrose?
Oh, dextrose, yes. I thought you were, I'm sorry, can you repeat your question?
What is the only way one can raise a diabetic's blood sugar?
Oh, sorry, yes, sugar, blood sugar. Any type of sugar, like dextrose would be an example.
And was Justin experiencing any more life-threatening conditions than hypoglycemia?
Yes, he had many injuries. Like I said, he had the spinal cord injury, the neurogenic shock, and he also had the concussion.
No further questions at this time, Your Honor.
Thank you. Anything further on recall?
No recross, Your Honor. However, may I approach this witness to tender Exhibit 7 to the bench?
Sure.
And may I approach the bench?
No. Thank you. All right, the witness is excused. Thank you very much. Plaintiff, call your next witness.
Yes, Your Honor. The plaintiff calls to the stand Cindy Burke.
Ms. Burke, come up to the stand for me, ma'am. You've previously been sworn. Thank
Yes,
you.
Your Honor.
Please proceed, ma'am, as soon as the witness is situated.
Yes, Your Honor. Can you please state your name and spell your last for the record?
Cindy Burke, B-U-R-K-E.
And why are you here today, Ms. Burke?
I'm here today to get justice for my son Justin, who was left quadriplegic after Forensic Tech failed to follow protocol.
Ms. Burke, how would you know if Forensic Tech failed to follow protocol?
Well, after all the events that happened, I spoke to Hayden Woodward in the hospital, and she went over everything that happened to Justin. And as well, sitting here today, I heard everything that happened, and I'm just so appalled.
Ms. Burke, I would like to get back to the incident in a moment, but right now, could you tell us a little bit about your son, Justin, before the incident?
Sure. Justin was such a great kid. He was super smart and was at the top of his class. He had diabetes, but we had it under control. He had just gotten accepted into USST and planned to study chemistry in college and hoped to become a forensic analyst, but now because he's a quadriplegic and he can barely move, I don't know if that's gonna happen.
Ms. Burke, you mentioned Justin had diabetes. Could you tell us a little bit about how he was diagnosed?
Sure. So in April, Justin started complaining of being hungry all the time, even though he was eating a lot. So, like any parent would do, I took Justin to the hospital, where they ran some tests and diagnosed Justin with type 1 diabetes.
And Ms. Burke, in your opinion, how is Justin handling his diabetes?
Well, at the several checkups Justin and I went to after his diabetes, the doctor agreed that Justin was handling his diabetes well, and from what I observed, the same held true when Justin went to Forensic Tech camp.
What is
Objection, Your Honor, this testimony goes to speculation. While the witness can testify to what they heard from the doctor pursuant to a medical diagnosis, they had no prior knowledge of Justin handling his diabetes while at camp because she was not there with Justin.
I don't think that's actually what she said while at camp, and I think she meant when he left for camp, is what I heard. Counsel?
Yes, Your Honor.
She's right, she can't say what happened during the camp, but I thought she was saying, well, when he left for camp and headed that way, he was fine.
Yes, Your Honor, I believe that's what she is
I'm
saying.
going to overrule the objection.
Yes,
I
Your
heard
Honor.
it differently, counsel.
Yes, Your Honor.
Thank you. Good.
Ms. Burke, what is Forensic Tech?
Forensic Tech camp is the camp where I sent Justin in the summer of 2018, where he came home quadriplegic.
And what made you decide to send Justin to Forensic Tech?
After Justin was accepted to USST, they sent us a list of recommended summer camps, one of which was Forensic Tech camp. I looked into it, but because it was accredited by the National Camp Association, I allowed it, assuming that they would uphold these standards.
And how are you familiar with the National Camp Association?
I am familiar with the National Camp Association because of my job. I work for Heaven on Earth Resorts, and as part of my job, I have to manage the many summer camps that we hold there and ensure the safety of the children.
Ms. Burke, if I were to show you a copy of the National Camp Association Mandatory Standards for Accreditation, would you recognize it?
Yes.
Your Honor, let the record reflect I am showing opposing counsel what has been previously marked as Exhibit 1.
It's noted.
Permission to approach the witness?
You may.
And would you like a courtesy copy?
Certainly.
Ms. Burke, what is this document I've just handed you?
This is the National Camp Association Mandatory Standards for Accreditation.
And does it appear to be a fair and accurate copy?
Yes.
Does it appear to be altered or changed in any way?
No.
Your Honor, permission to move Exhibit 1 into evidence.
Any objection, counsel?
No objection to it this time, Your Honor.
It's in then.
Your Honor, at this time, may I tender these exhibits to the jury box?
You may.
Ms. Burke, can you explain a little bit about the program trip and travel standards?
Sure. So before a camp allows a camp counselor to take any campers on an off-site hike, they need to have a pre-trip orientation where they discuss any emergency situation that might arise and the contact information. But to my knowledge, that didn't occur, and there also needed to be a detailed itinerary provided, and from what I heard, that didn't happen either.
And Ms. Burke, to your knowledge, were there any other guidelines that Forensic Tech didn't exactly uphold?
Yeah, so from what I heard from Hayden Woodward, River Forest was the only camp counselor there. And it specifically states that there has to be 2. And that put Justin's safety at risk, and he was never going to be the same.
And is there anything else about the National Camp Association mandatory standards for accreditation that Friends of Tech did not exactly uphold?
Well, from what I've heard today, Frenzy Tech Camp did not provide any emergency transportation. They relied on the emergency personnel, and that left Justin at the bottom of a creek with his spinal cord injury for 4 hours.
Ms. Burke, I would like to talk a little bit more about your son. Could you tell us a little bit about the day he left for camp?
When Justin left for camp, I had to catch an early flight to Greece that morning. I was on my way out the door when I remembered, oh my gosh, I forgot to tell them of Justin's diabetes. So I ran and woke Justin up, and he assured me he would tell them of his diabetes. I had to catch my flight, so at the time I wasn't able to call them myself.
And did you and Justin share any other conversations about camp?
Later on that day, Justin texted me that he had packed his insulin, so to me, I understood it as he would be taking care of his diabetes while at camp.
And what, if any, other conversations did you and Justin share?
Justin and I talked the next morning. He told me he forgot to tell the camp nurse about his diabetes, but would do so following our phone call. I trusted Justin, but just in case, I tried to call Frenzy Tech myself.
And Ms. Burke, what happened when you tried to call Friends of Tech?
Not only did Frenzy Tech not answer my phone call, but it went straight to voicemail. And they were supposed to be taking care of my son, and they couldn't have the decency to even pick up.
Did you and Justin speak again?
Justin and I spoke on Monday, Tuesday, and Wednesday, but on Thursday I waited for his call. I waited all day, anxiously by the phone. And then I finally got a call, and I thought it was Justin, and I got all excited, and it was the worst phone call of my life.
Ms. Burke, who was it that called you?
It was Hayden Woodward telling me that Justin had been in a horrible accident, and I needed to rush home immediately.
So what did you do when you rushed home?
I went straight to the hospital, and Justin was in the ICU. He was struggling for his life before my eyes, and I couldn't do anything to help him. He was in a neck brace, and he had tubes coming out everywhere. I almost passed out.
And Ms. Burke, how is Justin today?
Today, Justin relies fully on me. He can't even so much as use the restroom by himself. It has completely changed our lives and turned it upside down.
Objection.
No further.
Your Honor, this testimony again goes to damages. We've already discussed the pain and suffering of Justin and his specific injuries have been discussed even through this witness. Further testimony to this does fall into the bifurcation.
Your Honor, in order to prove damages, we have to prove...
You've already proven the injury, counsel. I'm going to sustain your objection.
Yes, Your Honor.
I've indicated I wanted you to move on from the topic.
And move to strike this testimony, Your Honor?
Just the last part of it, the last sentence from the lady.
Yes, Your Honor.
Let's strike it. Jury shall disregard. Please proceed.
Yes, Your Honor. Ms. Burke, do you regret sending Justin to Friends Tech?
Of course. I mean, I sent him there, a normal kid, and he came back a quadriplegic.
No further questions, Your Honor.
Thank you, ma'am. Cross.
Yes, Your Honor. Your Honor, may I inquire how much time I have for my cross-examination?
You may, from those ladies that are holding watches over there.
7 minutes. Thank you. Now, Ms. Burke, I understand that this is going to be difficult, but I'm going to have to ask you a few questions about your son. Is that all right?
Yes.
Now, Justin was first diagnosed as a type 1 diabetic April 20th, 2018, correct?
Yes, that's when Justin was diagnosed with diabetes. It was a shock to me, but I ensured that Justin talked to the best doctors about his diagnosis.
That's right, and one of these doctors was Dr. Madison Roper.
Yes, that's true.
Dr. Roper was the one who diagnosed Justin as a type 1 diabetic?
Yes.
And after diagnosing Justin, she had made recommendations to you on steps to take to ensure Justin's safety, living as a type 1 diabetic, correct?
Yes, that is true.
And one of these recommendations was for Justin to have an indication of his type 1 diabetes, such as a medical ID necklace.
Yes, that's true. So, being Justin's parent, I bought this for Justin, and of course I tried to enforce that Justin would wear it.
But Justin didn't really want to wear his medical ID necklace, did he?
Objection. Your Honor, this question calls for the witness to speculate.
May I respond, Your Honor?
Mm-hmm.
This witness can testify to the rational perceptions that they perceive based on the actions of Justin and the conversations they had about the topic. Therefore, it would not be speculation. It would be a proper lay opinion.
I think it's a proper lay opinion. If the lady can answer the question, if she cannot, she won't.
Yes,
The
sir.
rule.
Yes, sir. So again, Ms. Burke, Justin didn't really want to wear his medical ID necklace, did he?
No, Justin was nervous that maybe people would see it, like his friends, and then treat him like he was disabled.
And you didn't enforce that Justin wear this necklace?
Well, obviously, I did my best. I really wanted Justin to wear it because I knew the importance, but he was a teenage kid. He wouldn't listen to me. I did my best as a parent. I really did.
And I understand that this is difficult, Ms. Burke, but you did not explicitly enforce that Justin wear this medically recommended ID necklace.
I did enforce it, but I recommended it, but I couldn't enforce it. I couldn't make him keep it on. I mean, he couldn't taken it off. I couldn't do much about it.
Now, Ms. Burke, Dr. Roper had also recommended that Justin not keep his diabetes a secret from those around him, correct?
Yes, so Justin told the camp, I'm sorry, so Justin told the school nurse about his diabetes.
And you didn't tell Dakota Piper's family?
No, Justin was the one who was handling his diabetes for the rest of his life, so he needed to be the one making the decisions because he needed to learn how to handle it, so I didn't take it upon myself to tell them.
That's right, but the Piper family was the one that was attending Justin and taking him to camp.
They took Justin to camp, yes, but ultimately I was Justin's parent and I knew about his diabetes, which was the most important thing.
But they didn't know about his diabetes.
No, there was really no need for them to know, in my opinion, and that's what Justin thought too.
Now you say that there's no need, but the Piper family, you heard Dakota Piper's testimony that the Piper family was given the registration form to update for Justin.
Yes, that's true.
And they didn't know about his diabetes, so they couldn't have updated this form at the camp.
Yes, well, they handed it to the Piper's family. They didn't hand it to Justin. Justin would have updated it if they handed it to Justin. That was not under my control. Justin would have updated it.
But you heard the testimony of Dakota Piper, right?
Yes, I did.
And Dakota Piper testified that Justin was handed his form, that he handed it to the Piper family after being handed the form.
I guess, yes, that's true, but Justin maybe didn't know what it was. I really don't know.
Now, Ms. Piper, I'd like to talk about his time at camp. Justin had to fill out a medical registration liability form before attending camp, correct?
Yes, I actually filled it out for Justin.
And you'd recognize a copy if I were to show it to you?
Yes, I would.
Your Honor, let the record reflect I'm now showing opposing counsel what's been previously marked as Exhibit 2. This is the copy we're showing to the witness.
Noted.
Courtesy copy, Your Honor?
Sure.
May I approach the bench? And may I approach the witness?
Absolutely. Thank you.
Ms. Burke, is this the registration and liability waiver form that you filled out for Justin to attend to camp?
Yes.
And it's a fair and accurate copy?
Yes.
And it hasn't been changed or altered in any way?
No.
Your Honor, the defense now moves to the introduction of Exhibit 2 into evidence per stipulation 2 in the orders on motions in limine. Both parties have waived objections to this document.
All right, it's noted. It's in there.
And may I publish the document to the jury?
Absolutely.
Now, Ms. Burke, on this document, it explicitly asks for any medications or medical restrictions to be listed, correct?
Yes, that's true. I filled this out in March, and as I already said earlier, Justin wasn't diagnosed until April, so there were no medications that he was taking at the time to write down.
Right, but from March, when Justin was diagnosed, and I'm sorry, from April, when Justin was diagnosed, and from Justin's arrival at camp in late June, there was a little over 2 months where you could have updated the form.
Yes, that's true, but Forensic Tech Camp really wasn't at the top of my mind. We had so many other things changing in our lives revolving around Justin's diabetes that Forensic Tech Camp slipped my mind until the morning Justin was heading off to camp.
That's right. And at no point during this 2 months did you attempt to contact them in any way?
No, I forgot about it, but I tried to contact them later on and they didn't answer my phone call, so there wasn't much I could do.
That's right. You say you attempt to contact Forensic Tech, but this was just one phone call?
Yes, I called them and it went straight to voicemail. I couldn't, if I would have called them more times, for all I know, they wouldn't have answered again. I couldn't do much more.
But Ms. Burke, an email is provided on the Forensic Tech registration form, correct?
Yes, but I had to mail this into Forensic Tech Camp, so I didn't have the email anymore.
And you didn't think to write it down before sending it back in case you did need to contact them?
Well, no, because I had their phone number.
And now, Ms. Burke, you spoke to Justin while he was at camp, correct?
Yes, I did.
And in these conversations, you learned that Justin had not told the camp about his diabetes, correct?
Well, Justin told me that he had not told them. He told me that on Sunday, but he told me he was going to tell them after that. And Justin was very reliable, so I trusted that Justin would tell Forensic Tech Camp.
But to your
and then I
knowledge-
tried to call them myself.
I'm sorry, but to your knowledge,
Your Honor, my witness was not allowed to finish her answer.
Well, I think the young lady's actually out of time for her cross-examination. I'm going to allow the witness to finish the answer, and I'm going to allow her to finish one more question to close up.
yes, Your Honor.
Ma'am, would you please finish your answer?
Yes, Your Honor.
Thank you.
Justin told me on the phone call that he hadn't yet told Forensic Tech Camp, but he would do so immediately following the phone call. And because Justin was responsible, I trusted him.
And ma'am, I understand what you thought about Justin, but in fact, to your knowledge, Forensic Tech was never informed of Justin's type 1 diabetes.
Well, actually, I don't know if they were or not. For all I know, they could have known about Justin's diabetes. Justin could have told them. I don't know.
But I'm sorry, to your knowledge.
You only got one.
Yes, Your Honor.
I'm going to stop you, counsel.
Yes, Your Honor.
Before they do, I'm going to. All right, thank you, counsel. Redraft, ma'am.
No. I'm sorry, Your Honor. Before we finish, may I tender the exhibits to the bench?
Absolutely.
And may I approach the witness?
Certainly. Ma'am, do you have a redirect?
No, Your Honor.
Okay. Ma'am, you may step down. Do you have any further witnesses on behalf of the plaintiff?
Would you like me to tender this document as well? I believe it was such a And may I approach the bench?
All right.
No, Your Honor. At this time, the plaintiff rested to keep the case.
All right. Thank you very much. Ladies and gentlemen, that's the case in chief on behalf of the plaintiff. I have exactly 7 minutes to 11. So we're going to take a break, come back here sharp 11 o'clock. So you get a 7-minute break, 7 to 5. The defendant's case in chief, my jury is reconstituted. Everybody's present and accounted for. Counsel for the plaintiff, are you ready to proceed as well?
Yes, Your Honor.
Defense, are you ready to proceed with your case in chief?
Yes, Your Honor.
Please call your first witness, ma'am.
Your Honor, the defense calls to the stand Dr. Hayden Woodward.
Doctor, you've previously been sworn, and if you have a seat at the witness box, please.
Yes, Your Honor.
Please proceed, ma'am.
Yes, Your Honor. Good morning.
Good morning. Before they begin, may I ask opposing counsel to move over as I cannot see the witness?
You may move around her, ma'am.
Yes,
She
Your Honor.
doesn't have to move, you can move.
Yes, Your Honor.
Remember, because you always need to let you have free movement around the well. So that means she can move, but it also means you can move. All right? So if you can't see anything at any time, feel free to move around.
Yes, Your Honor.
All right? Go ahead.
Yes, Your Honor. Please introduce yourself to the judge and the members of the jury.
Good morning. My name is Dr. Hayden Woodward.
And what's your occupation?
Well, first and foremost, I'm a forensic pathologist, but currently I'm the founder and CEO of Forensic Tech Incorporated.
Now, you mentioned you have a history with forensic pathology. Where did you receive your education?
Well, I graduated from Baylor College of Medicine. I then went on to a 4-year residency in pathology at Texas Southwestern Medical Center, and then after that, I went on to a 2-year intense fellowship at UNC Chapel Hill, also in pathology.
And what is pathology for the members of the jury?
Pathology is the study of the cause and effects of diseases.
Now, Dr. Woodward, I'd like to discuss your involvement with Forensic Tech Incorporated. How did you first become involved with the company?
Well, back when I was a medical examiner in North Carolina, my kids were starting middle school and starting to get really busy, and my schedule was pretty intense as well. So I didn't really get to see them a lot. So I wanted to find a way to bring us back together. And something that we as a family really enjoyed was watching CSI shows like NCIS. So I wanted to give the kids an experience like that. So I looked into a couple different camps and things like that, but everything was really high on flash and low on content. So I started Forensic Tech with my own kids and other kids like them in mind to give them a really deep dive into forensic careers and forensic analysis.
And what was your role at Eden University's camp in the year 2018?
In 2018, I was the blood spatter analyst teacher as well as the camp director.
And as the camp director, how did you organize the camp?
Well, first and foremost, I went about hiring the instructors for the camp for that year. Fellow medical examiners, ballistic experts, forensic entomologists, you name it, we had it. Then I went about hiring the mentors or the camp counselors. They're from local colleges and universities, and they're to make sure that the kids have a fun time as well as an educational time. And thirdly, I make sure that every single campus has an on-staff 24/7 nurse.
And how do you go about hiring camp counselors?
Well, the process is pretty rigorous. They must fill out a pretty complete application, and then after that send in a few personal essays, and they must be background checked as well.
And do you do anything as the camp director and the CEO of these camps to ensure the safety of the campers that are under your care?
Of course. We take a lot of steps to make sure that we have everything that we need to properly care for and accommodate for the campers.
And how do you go about doing this?
Well, primarily before the campers are officially registered, they have to fill out a pre-registration liability and waiver form.
And would you recognize a copy of this form if I were to show it to you?
Yes, I would.
Your Honor, may I now retrieve what's been previously entered as Exhibit 2?
You may.
And may I approach the bench?
You may. I believe this is what you're looking for.
It is. Thank you. And may I approach the witness?
Absolutely.
Dr. Woodward, can you briefly explain this document for the members of the jury?
So this is the registration and liability and waiver form. This just gives background information, which is important in case we ever need to contact any parents. And then the most important part of the form is these two lines right here that say medications and restrictions or important health information.
And have you personally reviewed this specific form?
Yes, this is Justin Burke's form. I reviewed it before he attended Forensic Tech.
And did Justin or Justin's guardian list any medical conditions?
Very clearly, right here, they both list none, which I later found out to be blatantly untrue.
And we'll discuss that in a moment, but Dr. Woodward, what happens generally when these campers submit these forms?
Well, as soon as the forms are turned in, the campers are officially registered for camp. And we actually encourage that the parents stay updated before their child attends camp and to stay in contact with us if any of the information changes.
And were you ever contacted by Sydney Burke?
No, I was not.
And previously to his arrival, were you ever contacted by Justin Burke?
No, neither was anyone to my knowledge on campus.
Now, Now, is there any other steps that the camp takes to ensure the accuracy of these forms?
Yes, like I said, with this medication and important health information being so crucial to how our camp runs, as soon as the campers step on campus, they have a chance to review their forms and make any necessary updates.
And did Sydney Burke update Justin's form upon his arrival to camp?
Well, what's actually funny about that is since the campers usually arrive with their parents or guardians, they usually just take over that process and update it for themselves. But Sydney didn't actually come with Justin to drive him on.
But did Justin update his form?
No, he did not.
So, to your knowledge, was anyone on campus aware of Justin's diagnosis as type 1 diabetic?
No, not me, not River, not any of my other staff members.
Now, Dr. Woodward, have any campers ever been seriously injured under the care of Forensic Tech?
Tragically, only one camper has ever been injured, and that was Justin Burke.
And to your understanding, why is this?
Well, Justin kept his diabetes a secret from us as a camp. And when you keep secrets, we can't properly care for Justin. Since he was an insulin-dependent diabetic, We needed this information to make sure that we knew when Justin would become incoherent, disoriented, and a danger unto himself. And because we didn't know this information, we couldn't properly watch out for and care for Justin.
And Dr. Woodward, do you believe that Forensic Tech bears liability for Justin's injuries?
Objection, Your Honor. This question asks the witness to testify to the ultimate issue.
May I respond, Your Honor?
Yes.
Your Honor, pursuant to Rule 704, just because testimony embraces the ultimate issue does not automatically make it objectionable, and the only exception to this is 704B, which only applies in criminal cases, and in today's case it's a civil case, not a criminal case, so no exception would apply.
But aren't you asking her to stand in the shoes of the jury and make the determination of whether or not there is liability?
Your Honor,
Responsibility?
I'm sorry, may I respond? Your Honor, I'm asking specifically based on the witness's perception of the events that occurred and the policies that they had in place. Since it's the belief of the Dr. Woodward that they could have prevented this, that it is a rationally based perception on a rationally based perception on the events that occurred.
May I respond?
Yes, ma'am.
Your Honor, the opposing counsel did not ask the witness to her knowledge. She said, do you believe Forensic Tech is liable, which is
That's exactly what she said, counsel. You're right. I'm going to sustain the objection. Who's good objection? If you want to rephrase it, you're allowed.
Yes,
And I'll
strike.
move to strike the jury. Yes.
Yes, Your Honor.
Yes, Your
The
Honor.
jury shall disregard it. Consider anything stricken.
Yes, Your Honor.
All right, please proceed.
Now, Dr. Woodward, to your understanding of the events, is it your belief that Forensic Tech bears liability for the injuries that Justin sustained?
Absolutely not. As a mother myself, I have 3 kids at home. I understand the pain and the horror that Sydney Burke feels right now. But Forensic Tech isn't liable for what happened to Justin. Like I said, because we didn't know about his diabetes, we didn't know that he could fall into a hypoglycemic state and become a danger to himself. Because this information was kept a secret from us, we were unable to properly take care of Justin and make sure that he was safe at all times.
No further questions at this time, Your Honor.
Thank you, ma'am. Cross, later.
Yes, Your Honor. May I proceed?
Of course.
Good morning, Dr. Woodward. My name is Marshoot. I'm going to be asking you a few questions, but first, I'd like to start off with a few things we can agree upon. You would agree with me that you're the founder and CEO of Forensic Tech?
Yes, very proudly.
You would also agree with me that you form these camps to introduce kids to the exciting and fun fields of forensics?
Absolutely.
Now, I want to get into the main goals of your camp. You would agree with me that the main goals of your camp are to be challenging, informative, and age-appropriate, correct?
Of course.
But you do not mention safety, do you?
I don't mention safety where.
In your 3 main principles.
I think it's assumed that when you're sending your children to a sleepaway camp that they'll be safe.
But you do not specifically mention it, do you?
No, I guess not.
And in fact, when you were working as an ME, you were fined $1,500 and
Objection, Your Honor, this is improper character evidence under Rule 401A1.
Brenda, may I respond? I'm not using this to show that because Dr. Woodward acted in one way now, that she's going to act in a certain way this time.
May I respond, Your Honor?
Yes, ma'am.
If opposing counsel is not using this to prove character, there's no relevance of this testimony in today's case.
Where are you headed with this, counsel?
Credibility.
I'm going to allow her to explore it.
Yes,
Go ahead, ma'am.
May I proceed?
Yes.
In fact, when you were working as an ME, you were fined $1,500 and placed on a 1-year probationary period, correct?
Yeah, it's pretty sad. The medical office that I worked in was pretty understaffed and underfunded.
But that is a yes to my question.
Yes.
Now I want to move on to talk about River. You would agree with me that you trusted River, correct?
Of course I did.
And although hesitant at first, you were ultimately the one who gave them permission to go on the hike?
Yes, it was a little bit spontaneous, but River had already had a hike planned for that night. He just changed the location.
Now, when he changed the location, you didn't specifically ask a route he was going on, did you?
He told me where he was going to a nearby forest.
You didn't specifically ask a route, though, did you?
A specific GPS coordinates, no.
So when the sheriffs called, you couldn't even give them a general location, could you?
He told me he was going to a nearby forest, and that's where I told them that he went.
But you couldn't give them a general path they went on?
No, I could not.
Now I want to move on to talk about before they left. You would agree with me that they were your only off-site hike, correct?
Yes, for that week.
But you didn't specifically check up on them before they left, did you?
No, like I said, River had this hike planned for a while, so we knew the plan and we knew what was supposed to happen.
But this specific hike was not mentioned when planning a hike, was it?
Like I said, the specific hike, no, because River changed the location.
Now, before they left and you didn't check up on them, if you had...
Objection, Your Honor, the form of this question is argumentative.
Well, it's cross-examination by its very nature. It's argumentative. I'm going to overrule the objection. Go ahead.
Yes, Your Honor.
Now, you didn't... Sorry, may I proceed?
Of course, go ahead.
Now, you didn't check up on them before, but if you had, you might have seen that there was only one certified counselor going, correct?
Objection, Your Honor, this is speculation.
May I respond?
Yes.
Your Honor, I'm just asking her to testify what she might have seen. She can reasonably infer to her knowledge as to what she might have seen.
Well, might is speculation. So I'm going to sustain the objection. You might want to rephrase the question, though.
Yes, Your
I
Honor.
understand where you're going. You're just asking it
Yes, Your Honor.
smidgen improperly. Right?
Yes, Your Honor.
Thank you. Go ahead.
Now, if you would have checked up on them, you would have seen only one counselor was going.
Well, what River told me is that Jamie Gray was going to be in attendance at the hike, and I didn't know if Jamie was meeting up with them at the camp or at the site, so it's possible, but I knew that Jamie Gray was supposed to attend with them.
If you had seen this, you would either stop River from going, correct?
Well, like I said, I didn't know where they were meeting up with Jamie Gray, so I could have assumed, I'm sorry, not assumed, but I knew that Jamie Gray was going with them, so I would have known that River would go with Jamie Gray.
So if you hadn't seen Jamie Gray with them at the campground, you would have asked where they were meeting up with them, though, or meeting up with her, would you not?
I guess, but I don't see how that's relevant.
And if you had asked this, River would have told you that she was no longer able to go. Wouldn't she have, or she might have, correct?
Objection, Your Honor, again, the use of the phrase might in the question. Which is
You can't ask her to
speculation.
speculate what someone else is going to say to her.
Yes, Your Honor.
Sustain.
Yes, Your Honor.
Now, Dr. Woodward, you would agree with me that it's your duty to check over all of your campers, correct?
Yes, of course.
But you deemed it unnecessary to check up on your only off-site excursion, correct?
Well, like I said, River had talked to me. He'd had a hike planned for weeks, like we knew what was
Objection, Your Honor. This witness has not answered my question. She never stated yes or no at the beginning and just began to ramble on.
Yes, she has. Madam, if you could be so kind as to simply ask the question answered. Answer the question that is asked and allow your counsel upon redirect to clarify any matters.
You need to
It's a
strike
good
that
question.
testimony.
It's stricken. Go ahead and ask the question again and see what answer you get.
Yes, Your Honor. And you deemed it unnecessary to check up on your only off-site hike, correct?
Yes, like I said, we had done some pre-planning.
No further questions at this time.
Thank you, ma'am. Redirect.
Just briefly, Your Honor. Dr. Woodward, did you take any precautions with this hike to ensure that it was going to be safe?
Of course.
Objection, Your Honor. Outside the scope of my cross-examination.
May I respond, Your Honor?
Yes.
I believe opposing counsel opened the door by talking about what this witness did or did not do in regards to the planning of this hike, and therefore they are allowed to be redirected into what
I think once you ask her what you would have done about knowing when they were going, if Ms. Gray was going to go with her, I think that infers the safety is an issue. So I'm going to overrule the
Yes, Your Honor.
objection. Thank you.
So again, Dr. Woodward, did you do anything to ensure the safety of this hike and campers?
Of course. Like I said, River had a hike pre-planned for weeks, and we made sure to check up on all the campers going. Dakota Piper was one of the campers that attended, and we made sure that she had her inhaler.
No further questions at this time, Your Honor.
Thank you. Anything I'll recross, ma'am?
No, Your Honor.
Thank you, ma'am. Ma'am, you may step down. Call your next witness, please.
At this time, defense calls Dr. Madison Roper to the stand.
Ma'am, would you come up here and take a seat in the witness box? Ma'am, you've previously been sworn.
Yes, Your Honor.
Thank you. As soon as the witness is situated, ma'am, you may conduct.
Yes, Your Honor. Good morning. Can you please introduce yourselves to the judge and to the jury?
Good morning. My name is Dr. Madison Roper.
And Dr. Roper, are you currently employed?
Yes, I actually have two practices. I work as a pediatric endocrinologist at the University of Utopia Medical Center, and I'm also the Associate Clinical Director in the Department of Pediatrics at the medical school.
And Dr. Roper, what is your educational background?
Well, I received my Bachelor's of Science in Biochemistry and Molecular Biology in 2002, and then I went on to the Stanford School of Medicine to get my MD, or Doctor of
Objection, Your
Medicine.
Honor. Facts not in evidence. Nowhere in Dr. Roper's affidavit does she state where she went to
schooling. Do you have any kind of CV for the doctor that indicates her background?
Yes, Your Honor.
And where is that?
We can enter it into evidence, Your Honor.
So counsel, have you seen the CV that's available to you from the doctors?
Yes, Your Honor.
Okay, the court's going to allow the witness to reference the CV.
Yes, Your Honor.
All right, thank you. Overruled. Go ahead then. I don't need it in evidence.
Yes, Your Honor.
Okay.
What is your educational background?
Well, I received my bachelor's degree in biochemistry and molecular biology, and then I went on to the Stanford School of Medicine to get my MD, or my Doctor of Medicine, with an emphasis in endocrinology.
Your Honor, at this time, defense moves to tender Dr. Madison Roper as an expert in endocrinology.
Any objection, counsel?
Yes, Your Honor. Pursuant to Rule 702, opposing counsel has not laid the proper foundation to prove that the expert's methodology is credible.
May I respond, Your Honor?
Yes, ma'am.
Your Honor, this is only, this Rule 702 only applies if this witness is giving conclusions about their findings, which this witness has not gone into yet. When this happens, we will lay proper foundation for this.
I'm going to go ahead and allow the witness to be recognized as an expert at this point in time in endocrinology based upon her background. In terms of the question the counsel may elicit, we'll hit those one at a time and you may object when they're appropriate.
Yes, Your Honor.
Thank you, ma'am. Please proceed.
Now, Dr. Roper, you mentioned endocrinology. Can you please explain to the jury briefly what endocrinology is?
Of course. So endocrinology is the study of the endocrine system, which are glands in our body that secrete hormones, which are chemicals that regulate our metabolism, our mood, growth and development, and other cellular processes.
And what diseases primarily affect the endocrine system?
Well, most commonly type 1 and type 2 diabetes.
I'd like to focus on this first disease. What is type 1 diabetes?
So type 1 diabetes is when a person's pancreas doesn't produce enough insulin. And insulin is meant to be glucose, which is a primary source of fuel for our bodies. And without this glucose, our bodies don't get enough blood sugar, which can lead to hypoglycemia.
Now, moving on, did you have an opportunity to treat Justin Burke in 2018?
Yes, I did in late April of 2018.
What did you treat Justin for?
Type 1 diabetes.
And in your first visit with Justin, what practices or methods did you enlist to treat him?
Well, as with all newly diagnosed diabetics, we like to focus on 3 very critical areas.
I'd like to take these critical areas one at a time. What was the first critical area?
So the first critical area we like to go over with our patients is how to monitor and maintain a proper blood sugar level.
And the second critical area?
We like to teach our patients how to recognize the physical signs and symptoms associated with hypoglycemia in the event if they were ever to enter a state of hypoglycemia.
And finally, Dr. Roper, what was the third critical area?
The third critical area is we teach our patients they need to build a support system, to have people around them who know about their disease.
I'd like to focus on this third area. Why was it important to notify others?
Well, it is a safety issue. In this case, Justin didn't tell others about his disease, which therefore risked his safety.
Now, did you recommend anything else to Justin Burke in this initial visit?
Yes, I strongly recommended that Justin buy a medical ID necklace or bracelet.
Did Justin...
Objection, Your Honor. Hearsay.
May I respond, Your Honor? This witness is testifying to statements she made to Justin Burke about Justin's diabetes and would therefore fall under exception 803-4, which is statements made for medical diagnosis or treatment, in which case this would be the treatment of Justin Burke.
Ma'am?
This is still an out-of-court statement going for the truth of the matter asserted.
There's an exception, though, in the hearsay rules that provide for it, so I'm going to allow it.
Yes, Your Honor.
It's medical treatment.
Yes, Your Honor. Now, did Justin Burke show any hesitancy to your recommendations?
Yes, he was very hesitant about telling
Objection, Your
others.
Honor. Speculation. The witness is testifying to the mindset of Justin Burke.
I'm going to allow the testimony. I believe she is capable of making the observation of how he reacted to her, suggestions, questions, medical experience, and certainly you may cross her on these issues.
Yes, Your Honor.
Go ahead.
Again, Dr. Roper, did Justin Burke show any hesitancy to your recommendations?
Yes, Justin was very hesitant about telling others and wearing the medical ID.
And after this initial visit, did you have any other opportunities to treat Justin?
Yes, so we met again that following Friday, per my regular protocol, and then again 2 weeks after. But it was at this third visit that Justin did express some concerning indications.
You say concerning indications. What do you mean by this?
Well, at this third visit, Justin still hadn't built his support system, and he still hadn't purchased the vital medical ID.
Now, Dr. Roper, I'd like to discuss your conclusions in today's case, but before this, did you have sufficient facts and data when reviewing this case?
Yes.
And did you rely on standard principles and methods in your field when reviewing this case?
Yes, I did.
And are the opinions you are about to share with the jury based on a reasonable degree of medical probability?
Yes.
Finally, Dr. Roper, did you review any documentation in today's case?
Yes, so I reviewed the affidavits of Dakota Piper, River Forest, and Dr. Chantal, and then I also reviewed the American Diabetes Association handout on hypoglycemia, the ER reports when Justin was taken in after the incident, my curriculum vitae, and the 2 reports that I initially drew when Justin was originally diagnosed with type 1 diabetes.
Is this common for experts to review documentation before testifying?
Yes, the more evidence I'm provided, the more accurate my opinions will be.
Now, you mentioned Exhibit 7, the ER record of Justin Burke. Would you recognize a copy of that if I were to show it to you?
Yes, of course.
Your Honor, at this time, may I approach the bench to retrieve what has been previously entered as Exhibit 7?
You may, and here it is. Somehow Exhibit 2 has run amok for me. Do you know where that happened to go? Is it over there someplace?
I believe
Exhibit
so.
2. Can I have it back?
Yes,
I should have gotten it back the last time before you sat down. I apologize, ma'am. Go ahead.
May I approach the witness?
Certainly.
Thank you. Now, Dr. Roper, what does this document tell you in regards to Justin's diabetes?
Well, when I originally reviewed this document, I was very surprised to see that Justin's serum lactate level was above average. His glucose and his insulin levels were both abnormally low, which are all signs indicative of hypoglycemia.
Now, Dr. Roper, based on your professional medical opinion, do you have an opinion as to whether or not Justin was experiencing hypoglycemia at the time of his fall?
Yes, it is undisputed that no one saw Justin eat or drink anything for the duration of the hike, and hiking for strenuous amounts of time, especially in a diabetic, will lead to hypoglycemia.
Now, what signs or symptoms could Justin be exhibiting if he were to be hypoglycemic?
Well, every patient is different. However, most predominantly fatigue, confusion, and lack of coordination.
And based on your review of witness affidavits, did anyone see Justin Burke experiencing these symptoms?
Yes, both Dakota and River did.
What symptoms did Dakota Piper witness Justin Burke experiencing?
Well, Dakota witnessed the Justin stumbling around, and also the confusion at around 3 a.m. in the shelter.
And what symptoms did River Forest see Justin exhibiting?
River also noticed the stumbling around of Justin through the duration of the hike.
Now, was Dakota Piper able to associate this with Justin's diabetes?
Objection, Your Honor. Speculation. Dr. Roper is not in the mindset of Dakota Piper. She would not know what
May I respond?
No, that's okay. She can't testify as to what somebody else thought, because she'd be testifying for merely their affidavit, and Dakota has already taken the stand, so I'm going to not allow it. I'm going to sustain the objection.
Yes, Your Honor. Now, Ms. Piper, did Justin's symptoms continue over the course of the evening?
Yes, they did. They became more pronounced at around 3 a.m. in the shelter.
Now, you say more pronounced. What do you mean by this?
Justin had woken up telling Dakota that he needed to go, all indicating that indicates confusion. And as he stood up, he also experienced a lack of coordination as he did tragically slip down the mountainside.
Finally, Dr. Roper, do you have a medical opinion as to whether or not Justin Burke's diabetes contributed to Justin's injuries?
Yes, it is my professional medical opinion that Justin was hypoglycemic at the time he fell down the mountainside.
Thank you, Your Honor. No further questions at this time.
Thank you, ma'am. Cross-examination.
Yes, Your Honor. May I proceed?
Of course.
Hello, Dr. Roper. My name is Julia Hughes. I'd like to start with a few things we can agree upon. You would agree that you have never testified as an expert witness before.
Yes, that's correct. This is my first time testifying in court.
In fact, you were at first reluctant when the defense counsel approached you about testifying.
Yes, I admit I was a bit hesitant at first, but upon reviewing the affidavits and the medical records, it became apparent to me that testifying for the defense is what I needed to do.
So that's a yes?
Yes.
Furthermore, you're being paid $10,000 to be here today.
Yes, but it is common for expert witnesses to be paid in preparation for their time testifying and appearing in trial.
But that's a yes, you are being paid?
Yes.
Now I'd like to talk about Justin Burke. Justin was a patient of yours, correct?
Yes, he was.
And you would agree that when Justin was diagnosed with diabetes, he seemed comfortable with the new information he was learning?
Yes.
Furthermore, at Justin's follow-up appointments, he brought thorough records of his dietary intake, his blood glucose level, and his insulin records, correct?
Yes. However, an analogy I like to give my patients is just because someone is a good driver doesn't mean they can't get into an accident. And it's the same case, just because Justin was keeping great records of his diabetes doesn't mean that he couldn't have a fit of hypoglycemia or hyperglycemia.
But he was keeping thorough records.
Yes, he was.
At those same follow-up appointments, Justin reported that all was going well.
Yes.
And he had experienced no instances of hypoglycemia.
No, he had not.
You would agree that Justin's understanding of how to monitor and maintain an appropriate diabetic glucose level was excellent.
Yes, it was.
Now I'd like to talk about the likelihood of Justin falling due to hypoglycemia. You have read the affidavits of Nikki, Chantal, Dakota Piper, and River Forest, correct?
Yes, that is correct.
So you're aware that when Justin entered the ER on June 28, 2018, his blood glucose was tested to be 40.
Yes, I am.
As an endocrinologist, you're aware that blood sugar can drop rather rapidly.
Yes.
You're also aware that if low blood sugar is left untreated, it will continue to drop.
That is correct.
You're aware that Justin fell down the mountainside around 3 a.m.
Yes.
And you're aware he arrived at the hospital around 7:58 a.m.
Yes.
So he was laying at the bottom of the mountain for about 4 hours.
That is correct, he was.
So Dr. Roper, Justin's blood sugar must have been higher than 40 when he fell off the mountain if it was 40 when he arrived at the ER 4 hours later.
Well, I admit it is a possibility. However, the American Diabetes Association recommends that when there is not a blood glucose test available, you must rely on the symptoms associated with hypoglycemia and treat them accordingly.
But that's a yes, it must have been higher than 40.
Yes, it is a possibility.
Is that a yes?
Yes.
Objection, Your Honor. This has been asked and answered.
Well, she sort of danced around the answer, so I'm going to overrule the objection, but we're done now. So thank you.
Yes, Your Honor.
I think we all know the answer.
Yes, Your Honor. Now I'd like to talk about how diabetes did or did not affect the incident in question. You would agree that diabetes is not a direct cause of quadriplegia.
No.
In fact, the direct cause of quadriplegia is a spinal cord injury.
That is correct.
And directly, diabetes has nothing to do with the spinal cord.
No, not directly.
You're saying that Justin endured a spinal cord injury after falling down the mountainside while experiencing hypoglycemia.
Yes.
So let's say Justin began experiencing hypoglycemia elsewhere, like on the camp's campus, playing flashlight tag. If he had begun experiencing hypoglycemia then, instead of on the side of a mountain, he would have been much less likely to have fallen and sustained a spinal cord injury, correct?
Correct.
If he didn't sustain a spinal cord injury, he wouldn't have become a quadriplegic.
That is correct.
No further questions at this time, Your Honor.
Thank you, ma'am. Redirect.
Yes, Your Honor, briefly. Well, Dr. Roper, just information at all affect your testimony in today's case?
Of course not.
And if a diabetic keeps thorough records, does this mean that a diabetic does not need to eat or drink anything for a long period of time?
No.
And when a blood glucose test is unavailable, is an endocrinologist able to rely on symptoms and signs to make a proper diagnosis?
Yes, that is correct. Even the American Diabetes Association strongly recommends this.
Thank you, Your Honor. No further questions at this time.
Thank you.
At this time, may I retender Exhibit 7 to the bench?
That would be lovely, thank you. Anything on recross?
No, Your Honor.
Thank you. Call your next witness as well. This is tendering, yes, please.
The defense would like to call Camp Counselor River Forest to the stand.
Sir, as you approach, you've previously been sworn. You're under oath.
Yes, Your
Have a
Honor.
seat. Once the witness is situated, sir, if you'd like to go.
Could you please introduce yourself to the judge and to the jury?
Good morning. My name is River Forest.
And how old are you?
I'm 21 years old.
Are you currently employed?
No, I'm a senior at Eden University, so I'm waiting until I graduate to find a job.
Were you employed during the summer of 2018?
Yes, I was a camp counselor.
Were you ever employed as a camp counselor prior to last year?
Yes, the year before that year as head camp counselor, I was a regular camp counselor.
And explain to the members of the jury what merited you to be promoted to such a position as head camp counselor.
So I actually recommended a lot of new activities to Camp Director Woodward, and therefore I had all of the certifications and necessary training to become head camp counselor.
And how was your first year as head camp counselor?
It was excellent. I enjoyed interacting with the students, making sure they didn't feel isolated or homesick, and it was just a blast getting to know all of them.
As head camp counselor, did forensic check require any formal training?
Yes, I was a lifeguard in high school, so I had all of my first aid training as well as some wilderness training. I participated in an 8-day outward bound backpacking adventure.
And did you ever have to put any of this training to use?
Yes, I saved 10 kids from drowning and performed CPR once.
And do you currently possess any wilderness experience?
Yes, like I said, I was a part of an 8-day outward bound backpacking and rock climbing adventure.
And what is the purpose of the daily afternoon activities of the summer camp?
So during the daytime, students are in regular forensics classes, and I decided that it would be great to have them go outdoors and participate in more adventurous activities. So I requested that to Director Woodward, and she loved the idea.
And what led you to the idea of a hike?
Like I said, it was a more adventurous activity, unlike ones we've done prior.
And what did you do to prepare for the hike in advance?
I mentioned to all the kids that if for whatever reason they didn't want to go on the hike, they could stay back and participate in the other activities. I told them that they should bring a water bottle, a towel, a life jacket, and...
Hearsay?
Your Honor, he's not mentioning any specific statements. He's just mentioning what he instructed the group members.
Well, he did say I told them, but he's also not, he's offering it for the purposes of what?
The effect on the listener, not the truth of the matter asserted.
Overruled. I'm
Yes.
allowing it. Okay, thank you, sir.
Yes, ma'am.
Yes, so I instructed all of the students that they should bring a water bottle, a towel, and a life jacket.
And did you consider the weather as a factor?
Yes, I checked the weather twice before going on the hike.
And would you recognize a copy of these documents?
Yes, I would.
Let the record reflect that I'm now showing opposing counsel what has been previously marked as Exhibits 12 and 13.
Noted.
Is this a copy of your two witnesses?
Courtesy copy, Your Honor.
Certainly. Thank you, sir. Oh, thanks.
May I approach the witness?
Of course.
Thank you.
And what are these documents?
This is the weather forecast for when I checked it on Saturday and then again on Monday.
Do they appear to be fair and accurate copies?
Yes, they do.
Do they appear to be changed or altered in any way?
They have not, no.
And now move for the introduction of Exhibits 12 and 13 in the evidence.
Any objections?
Yes, Your Honor, here today.
Okay. Counsel?
Your Honor, defense is just presenting these documents to show the effect they had on the listener and what River Forest did as a reaction, not to prove the truth of the matter asserted. Now, if you do think that these are still hearsay, under Rule 803.8, these are public records and accessible to everyone.
Right. And the court could take judicial notice of their existence, right? Because it's the American Weather Service forecast.
Yes.
Okay. I'm going to overrule your objection. Go ahead.
May I publish a copy to the jury?
You may.
And after you consulted these documents, explain to the jury what you did.
Okay, so when I checked it on, this one is Saturday. So when I checked it on Saturday, the day of the hike is Wednesday, and it appeared to be sunny and 67, and it wasn't supposed to rain until Friday. And then when I checked it again on Monday, for the day of the hike on Wednesday, it was sunny, 66, with again 0% chance of precipitation.
And describe the events leading up to departure in your hike Wednesday, June 27th.
So I ran the hike by Camp Director Woodward, and she assured me that it would be a great opportunity for the children.
And regarding the hike, did everything go as planned?
No, the Venture Club president, Jamie Gray, was supposed to go on the hike, but she called in sick 15 minutes.
And explain what happened on the hike.
So it started out okay. The kids were having a blast. We were rock hopping in the stream, and it was going exactly as planned.
Did you notice any of the students struggling?
Yes, it was very unusual because all of the other kids were having a blast, but then Justin, who was...
Speculation.
It's from his observation. I'm going to allow it.
Yes, Your Honor.
But Justin, one of the most athletic students, seemed to be struggling.
And what did you do in response to seeing Justin and some of the students struggle?
Okay, so I had packed ahead of time granola bars and I offered them to all of the students, but Justin declined.
And did the fact that Justin did not eat or drink anything concern you?
At the time, no. I just assumed he'd stayed up late and was just exhausted from that.
And now, did you ever try to hike back to the van?
Yes. When I realized it was 7:30, I decided to hike back to the van and see if we could make it on time. But it started getting dark and a little cloudy, which was unusual because when I checked the forecast, it wasn't supposed to rain. So I decided we needed to head back to the van and try to secure there.
Now, did you ever make it back to the van?
No, it started raining and we needed to stay in place and build a lean-to shelter.
Now, how close attention were you paying to the students' health?
Very close attention. I made sure all of the students were in good spirits and we were all staying in place for the emergency personnel to arrive.
What did you do next?
So I hiked up to the top of the mountain to contact emergency personnel, and I also implemented the buddy system so that if, for whatever reason, the students wanted to leave the shelter, they would have another person with them.
Did anyone ever fall asleep during the night?
Eventually, yes, but for every half-hour period, we would yell out for emergency personnel.
And at what time did Justin's fall occur?
Justin's fall occurred around 3 a.m.
What did you hear upon Justin falling?
So I woke up to a scream and I said, "What was that?" And Dakota said that Justin had fallen. So I immediately rushed down to the stream and made sure I stabilized Justin's head and neck and got him out of the freezing stream.
And did you ever locate medical assistance?
I decided that it would be too risky to head out and find medical assistance at that time because it was still dark and pretty slippery and I didn't want any students to get further injured.
And did you ever find out that Justin was a type 1 diabetic?
No, his liability form did not mention anything of it, and no one told me of Justin's diabetes.
And do you feel that you made any mistakes during the course of the hike?
Although I did make some mistakes with planning the hike, I made sure all of the students were in good spirits and we were prepared for the hike. I packed all of the necessary essentials and made sure all of the students were safe throughout the whole hike.
And had you known that Justin was a type 1 diabetic, how would you have changed your supervision?
I would have completely altered the plans. If
Speculation.
Yeah. In accordance with Rule 701A, this is rationally based on the perception of the witness.
I think he's just saying what he would have done if he had known, and I don't think that's speculation because it's his testimony.
Yes,
So I'm going to allow it. Go ahead.
Now, had you known that Justin was a type 1 diabetic, how would you have changed your supervision?
I would have completely altered the plans. Justin, if I had known about Justin's diabetes, I would not have allowed Justin to go on this trip. There were two other options for that night. The students could stay back and play a dodgeball game or lounge by the pool, and that would have been a much better option for Justin.
No further questions at this time.
Thank you, sir. Cross-examination.
Yes, Your Honor. May I proceed? Mr. Forrest, you planned for an off-campus hike for Wednesday, June 27th. Is that correct?
That is correct, yes.
And you did not check the weather the day of the hike. Is that correct?
No, I checked it Saturday and then again on Monday, and once again, both times it was 0% chance of precipitation, so I thought it was great hiking weather.
But that's yes to my question. You did not check the weather the day of the hike.
Yes, that is correct.
Now, Mr. Forrest, on this hike, you did not bring a GPS, did you?
No, I did not.
You did not bring a compass either.
No, I did not. The Venture Club president gave me detailed instructions on where we were going and what we were going to get into.
Yes, exactly. You would agree with me that the only directions that you had to this location you had never been to before were verbal. Is that correct?
That is correct. Very detailed verbal instructions.
Now, I want to get on more to the hike itself. At some point during the night, you got lost. Is that correct?
Yes, we did.
And you spent the night on the hike. Is that correct?
Yes, we did. We wanted to make sure we stayed in place for any emergency personnel and did not hike back to the van because it would have been too dangerous.
And you awoke to a scream that night, correct?
That is correct, yes.
That scream was Justin Burke.
Yes.
And after further investigation, you realized you found Justin lying in a stream. Is that correct?
Yes, I did.
And you opted to move Justin. True.
Yes, I thought it would be the best decision to move Justin out of the freezing stream because he could have suffered hypothermia, which I'd studied in my classes.
Yes, you opted to move Justin using the B method. Is that correct?
That is correct, yes.
And you enlisted the help of Dakota Piper to do this.
Yes, I stabilized Justin's head and neck, and Dakota held Justin's legs.
But Mr. Forrest, you would agree with me, though, that the B method actually requires more than two people to properly move someone with a potential spinal cord injury.
Yes, so there are different methods that the Red Cross suggests. However, there are other options in which two people can move someone.
So you would agree with me that you were failing to follow proper B movement protocol when you opted to move Justin with only the help of Dakota?
The B method, that is correct, yes.
Now, in order to go on this hike, you had to get permission from Dr. Woodward, is that correct?
Yes, I did.
And in order to get permission from Dr. Woodward, you had to imply to Dr. Woodward that you had been on this hike before.
Yes, so because I was given detailed instructions from the Venture Club president, I assumed that I could just run it by Director Woodward and imply that I had been there before.
But Mr. Forrest, let's be clear for the jury, you had never been on this hike before, had you?
That is correct. I implied to Director Woodward that I had been there.
And you had never been to the location that this hike led to, is that also correct?
That is correct. I was only given instructions.
Only verbal instructions to a location to a hike only verbal instructions for a hike to a location you had never been to before.
That is correct. The Venture Club president had heard of the majestic waterfall, and I decided it would be a great opportunity.
So that's a yes to my question?
Yes, that is.
No further questions.
Thank you, ma'am. Redirect?
Yes, Your Honor, briefly. What instructions on the course of the hike were you given?
So, The Venture Club president gave me very detailed instructions on where to go and when to turn. Yes.
And would you say you treated Justin Burke in accordance with your extensive first aid experience?
Yes, I was a lifeguard in high school and I had all of the necessary certifications. I learned that it was very necessary to stabilize his head and neck as well.
No further questions. May I tender the exhibits to the bench?
Yes, sir. Anything on recross, ma'am?
No, Your Honor.
Thank you, ma'am. Does the defense have any further witnesses they'd like to call? Thank you, sir.
No, Your Honor, the defense rests its case in chief, but may we request a brief recess before continuing with closing arguments?
Yes, ladies and gentlemen, we actually are doing really, really well. It is about 12 till 12 by my watch. It is also snowing out. It looks like a winter wonderland out there in March. So here's what we're going to do. We're going to take 5 minutes so everybody can get ready for their closing arguments, stretch your legs a bit. So I want you all back here at 5 till 12. Session, the jury is reconstituted. I have 5 till 12. All right, I believe we're ready to proceed with closing arguments. Plaintiff, unlike in Kentucky, it's my understanding you're going first on
Yes, Your Honor.
closing. Ma'am, your argument. Are you reserving time for rebuttal, by the way?
Yes, Your Honor. Per mock trial rules, it is not needed to reserve in advance.
Okay, thank you.
May I proceed?
Certainly.
May it please the court, opposing counsel, members of the jury. Forensic Tech ignored protocol, which caused Justin to fall. On June 28, 2018, Justin Burke's life changed forever at the hands of a reckless camp. While attending Forensic Tech camp, Justin participated in an off-site hike gone wrong due to the defendant's negligence. During this 13-hour nightmare, Justin sustained multiple injuries, including a severe concussion and a spinal cord injury that rendered him a quadriplegic. Justin was bright and bound for success. When he was diagnosed with type 1 diabetes, he took it in stride and learned how to manage it well on his own. Even his endocrinologist admits this and says Justin never had any issues with hypoglycemia. The defendant is trying to put the blame of their actions on Justin for being diabetic, yet wanting to remain a normal kid. But members of the jury, you and I both know this accident could have happened to any of the campers. Forensic Tech ignored protocol, and that is what caused Justin to fall. We hold the burden of proof in today's case. It is our constitutional obligation to prove to you by a preponderance of the evidence, which simply means that it is more likely than not that Forensic Tech acted with gross negligence. Imagine the scales of justice. If, after hearing all the evidence today, the scales tilt even slightly in our favor, you must find the defendant liable. To find the defendant liable, we must prove to you 4 elements, which we successfully did today. 1, the defendant had a duty. The case Lesser v. Wildwood tells us that under Utopia law, camps supervising minors under the age of 18 have a duty to exercise the same degree of care as would a reasonably prudent parent under similar circumstances. The defendant had a duty to care for and protect Justin. 2, the defendant breached that duty. The defendant failed to exercise ordinary care when River took the campers on a dangerous hike to a location he had never been to before, without sustainable sustenance, without a charged phone, and without even a compass. 3, the defendant is responsible for both direct and proximate cause. The defendant is the direct cause of Justin's injuries. If River had just followed protocol and never taken the campers on that dangerous hike, Justin never would have fallen down the mountain and hit his head. The defendant is also the proximate cause for Justin's injuries. Justin's injuries were a foreseeable result of taking the campers on a hike without proper direction and could have been anticipated. River knew he did not know the hiking route and knew that this could have resulted in campers getting lost or campers getting hurt. 4, fair compensation is to be awarded to the Burkes for the damages endured by Justin. Members of the jury, Justin will never live the life he could have because of the defendant's negligence. Not only have we proven negligence, but we have proven gross negligence. To prove gross negligence, we must prove a lack of care that demonstrates reckless disregard for the safety or lives of others. The case Yancey v. Lee describes gross negligence as an intentional misconduct or intentional wrongdoing. The defendant acted with gross negligence when he intentionally took the campers on a hike without proper direction. He knew it was getting late, but intentionally did not turn back. He knew a storm was coming, but intentionally did not turn back. He knew he was responsible for those campers' safety and lives, but intentionally disregarded that entirely. Members of the jury, the defendant is liable. All we are asking is that you hold him responsible for his actions. Find the defendant liable for gross negligence, because it's the only verdict the law requires, the facts compel, and justice demands. Thank you.
Thank you, ma'am. Close. Okay.
Yes, Your Honor. A bracelet, a conversation, simply ensuring the accuracy of medical information given. Any one of these simple indications could have prevented the tragedy that occurred on June 27, 2018. But no, you see, Justin's diabetes was a secret, and secrecy is the enemy of safety. May it please the court, opposing counsel, and members of the jury. Our case today is about this secret, a secret that was kept between mother and son, one kept from close friends, kept from Forensitech, and kept from the world. Now, Justin and Sydney Burke allege that in operation of its summer camp, Forensitech had a reckless disregard for the lives of its campers. However, you've heard the director and CEO of the company come before you and testify there had only ever been one camper injured under the supervision of Forensitech, Justin Burke. Members of the jury, this is no coincidence. Justin Burke had kept a secret upon arriving to camp that summer, and in keeping his diabetes a secret, Justin and Sydney Burke consequently prevented the actions that could have been taken by Forensitech to prevent the injuries that Justin sustained. Now, today you've heard from a number of witnesses. Foremost, you heard from Dr. Hayden Woodward herself. Dr. Woodward came before you to testify to the numerous policies that the company has in place to ensure it has all medical information necessary to exercise ordinary and proper care over its campers. The first of which is a mandatory registration and liability waiver form. This way they have all the medical knowledge of their students. Justin and Sydney Burke, they listed none. And the second of which is mandatory verification of this same form to ensure that this medical information has not changed. But neither Sydney nor Justin ever updated the form. There was not one call, not one email, not one conversation. Furthermore, you heard from Dr. Madison Roper. Dr. Roper is a practicing pediatric endocrinologist that diagnosed Justin with type 1 diabetes. Upon diagnosing Justin, she had made numerous recommendations on imperative steps to take to ensure Justin's safety living as a type 1 diabetic, though Justin and Sydney had ultimately neglected to follow these as well. The first of these recommendations was for Justin to have some sort of indicator of his status as a type 1 diabetic, though Justin didn't want to wear his medical ID necklace. And as you heard Sydney Burke testify, she didn't feel the need to enforce it. Dr. Roper also recommended not for Justin not to keep his diabetes a secret from those around him, though Justin also ultimately chose not to do this. As you heard, it was in Dr. Roper's expert medical opinion that Justin could fall into a hypoglycemic state from a lack of insulin. Telling people around him would be so that they would be aware of this condition, though, as you heard Dakota Piper testify, she was not aware. As you heard Dr. Hayden Woodward testify, she was not aware either. And you heard River Forrest, the camp counselor taking care of Dakota Piper, neither was he. Members of the jury, it's in Dr. Roper's expert medical opinion that Justin was suffering from hypoglycemia at the time of the incident. Caused from a lack of insulin in Justin's body from his refusal to eat the night before, he started exhibiting symptoms of weakness, poor coordination, and difficulty thinking clearly. All of these symptoms Dakota Piper testified Justin exhibited just seconds before his fall. It was these symptoms that led Justin to fall that night and sustain these catastrophic injuries, and not a single other camper walk away with anything more than minor scrapes. Finally, you heard from River Forest, the camp counselor of Dakota Piper and Justin Burke. Now, in hindsight of what was intended to be a fun, nature immersive hike, River recognizes that there should have been more thorough planning involved. However, neither prior nor during the hike was River ever informed of Justin's diabetes. This secret made it impossible for him to account for this substantial factor. River didn't exercise a reckless disregard for the lives of his campers. He took precautions that night to ensure their safety, though Justin ultimately neglected to follow these as well. Members of the jury, this case is truly devastating. A 16-year-old, a child, was injured, but it is imperative that when making a decision on this case, you can separate the sympathetic feelings of getting justice for Justin from reliable and consequential facts. And in doing so, you will find that while this was a tragedy, it was not ultimately the fault of gross negligence on Forensitech's part that caused it. We ask you to find the defendant not liable, as it's the only verdict that the facts compel, the law requires, and justice demands. Thank you.
Thank you, ma'am. Rebuttal, ma'am?
Yes, Your Honor. Before I begin, may I request how much time I have?
You have 36 seconds.
May I proceed?
Mm-hmm.
May it please the court, opposing counsel, members of the jury. Secrecy is the enemy to safety, and it was River Forest's secrets that altered Justin's life forever. River kept it a secret that Jamie Gray was no longer participating in the hike. River also kept the hiking route a secret. The defense is trying to use Justin's diabetes to distract you from the fact that Forensitech ignored protocol, and that is what caused Justin to fall. Find the defendant liable for gross negligence because it's the only verdict the law requires, the facts compel, and justice demands. Thank you.
Thank you, ma'am. All right, ladies and gentlemen of the jury, would you like to adjourn? And I don't know where you're adjourning to. Are they going, Jim, are they going downstairs? Jim,
I will take the ballots directly from them in here, and
Oh.
then we'll take them and bring back.
Okay,
the
so
results.
are you going to come up and get them then? And how about if I'll talk to you while that's going on, if that's okay? All right, well, today has been a pleasure for me. I have been a judge for 22 years this year.
You also have a ballot?
No, I didn't.
Oh, you just, okay.
I did not score, I was told not to.
Okay.
So I've been a sitting judge for 22 years, and I have taught at Chase since 1989. And what I teach is trial ethics. And you are welcome to come and help me teach anytime you want. I think that you've all done amazing work, amazing work. You know the rules of evidence and the way to lay a foundation much better than my third-year law students do. And I'm going to tell them I said that. So no more excuses why they're having a hard time figuring it out. You guys were concise, to the point, respectful to each other and to the court, obviously. And that matters, right? Civility matters. Judges care about civility to each other and of course to the court. And I thought your arguments were compelling. And I thought the amount of work you all must have put into this absolutely positively showed through, right? So whoever wins, right? That only meant that you prevailed today. Did it mean that the other side lost? I don't look at it that way, right? It's just today they happened to prevail. You all won, I think, because of the job you did. I mean, golly, you've been working on this since, usually it's about 3 months, 4 months, something like that?
Since October.
October? So, 5 months, right? That's a long, I heard somebody say October. I'm sure your parents have heard opening and closing arguments over and over again, right? Yes. That happens. I know when I did mock trial competitions or my trial advocacy course, I know my mother would hear mine over and over again. The poor one was sick of it. Your families, obviously you know this, right? You wouldn't have been able to do all of this without them. They carted you all over the state. Where did you start your competitions, by the way?
We started at the UK competition in January.
UK?
Yeah, that was our first competition as well.
And then where did you go from UK?
Regionals.
Regionals, and the regionals were here?
Louisville.
So you went from UK to Louisville, and then up here?
Yes.
Oh, you have been around the state. Okay, well, so you've moved all over the place. You've had lots of travel. I'm sure that they will be dealing with the ballots fairly quickly, so you all can get home safe and sound, right? I don't want anybody has any problems with the snow. Do you all have any questions for me about anything I ruled on? In any way, shape, or form? You know, the thing you have to remember about judges is we make mistakes all the time, right? And I might know the rules of evidence, and I might know the case law, but it's also how I hear something, right? You heard me say that a couple times. I heard, and so it depends on how I hear it. And that's how judges sometimes rule about how they hear something. And what I will tell you is if a judge rules on an objection you get sustained, don't give up, right? Don't give up. Just because you got shut down on that particular question, I mean, y'all did a pretty good job of that. Coming back, and I have tried to help you a little bit. You want to rephrase, and I'll be honest with you, I didn't do anything for you that I don't do for my sitting attorneys. Right, when I try cases, it's the teacher and me and the old trial attorney. I will be honest with you, because I tried cases for a living before I went on the bench. That well that you're all roaming in, I feel like it belongs to the attorneys, right? So it's your well, it's your field, it's your process, it's your place. Not every judge feels that way, right? There's some judges that will require you to use a podium in real life. There's some judges that will ask over and over. They want you to ask, can I approach the witness? Can I do that? My rules are, you don't have to ask to approach. You know, just don't jump on top of the witness. You know, don't be too close to them, but you don't have to ask to approach. You don't have to ask to approach the bench once we've laid out the ground rules of what you're using isn't a case. So every judge is different, right? I probably tried this case much differently than any of the other judges have tried it, right? Sorry about that, if I threw you off a little bit. And that's because I haven't tried it with any of you before, right? Usually I've had the luxury of trying one or two of the practice rounds or the regional rounds, but you've got a fresh judge, so you had a fresh perspective. I think I just want to make mention of the one thing, is the reason I say that is I give you permission to move around the well, is that if you are blocked ever again in any other competition, and you just ask the judge, may I move about the courtroom so I may see, right? You don't move the other counsel around, you move. Okay. Now, maybe there's some judges out there who will force counsel to move. I don't, because they're trying their case, they're practicing their case, right? So for me, it's a very different process. So I always, make sure everybody moves. I thought you all did an excellent job, by the way, of keeping the jury engaged with eye contact, both as attorneys and as witnesses. You're all very engaging witnesses. Lots of doctor talk. I was very impressed with the doctor. So, I think you all have immense talent, right? Do you all want to go into law, or is there something else you all want to do? Yes?
I'm going to law school.
Yeah.
You're going to go to law school? Okay. Yes? Yes?
Yeah.
Thinking about it? How about you guys? No. That's okay. I didn't either. You know what? When I was in college, I was horribly shy. In high school, college, this would have been a terrifying experience. So I took theater classes in college. I was a theater minor. So I could stop my knees from shaking because I knew I wanted to be a trial lawyer. So you're just getting that out of the way much sooner than I did. Though I had a lot of fun acting. But I think that, if you want to go to law school, I think that's great. If you don't, that's okay too. The experience of getting on your feet, right? Learning to deal with situations, learning to deal with adversity, learning to deal with the logical problem and how it's presented is good in any field you decide to go. Are you all close to graduation?
I'm a senior. Yeah.
Senior, junior.
Both of us.
And we have a sophomore too.
Oh my gosh. Well, you guys have got great careers ahead of you, yes.
I'm a senior.
You're a senior, you guys are seniors?
Junior.
You're
I'm a
younger,
fresh-
junior?
I'm a junior.
Did I hear freshman?
Yeah, freshman.
You did great. You did wonderfully. The fact that your teams have so many now experienced attorneys on them, right? That you've been through this once, you're going to lose your three graduating seniors, and that's always sad. But you've got great people coming up behind you. In your local jurisdictions, I'm going to put a plug in for my mock trial groups. In your local jurisdiction, do they have teen courts?
We're both from,
Yeah, we do in Oregon.
So are you on?
I know it.
I'm like, I know you guys, and I know you too, and I know you. Well, I couldn't claim them before. All right, so I know you guys, but you guys, you know teen court?
I haven't done it yet, no.
Just try. Try teen court. It's a good experience, right?
Yeah.
Yeah, you like doing it? You get to meet real defendants. We do real criminal cases in teen court. These are juvenile defendants who have admitted their guilt to a criminal offense, sometimes status offenses, sometimes traffic offenses, but mostly criminal offenses that are misdemeanors or nonviolent D felonies, and need to be sentenced and tried and defended by peers. So the teen court, comprised of anybody that's in high school, we train for about 6 weeks. And then we start trying real cases and real criminal defendants, real juvenile people, the real family issues, real problems, real issues, right? You guys have seen a lot. They get exposed to everything imaginable. And I always tell most of my teen court folks that it's always there by the grace of God, right? Is that you've all got great families and loving parents and things like that. And you can see some of our folks have challenges that come into teen court. They're one-parent families. They've got other challenges, mental health issues, substance abuse issues. So these children are exposed to the realities of life and how to deal with them and how to be positive and a good role model. So we train how to be a defense attorney, how to be a prosecutor, and how to be a juror in a restorative justice model, to be someone that can hand out a sentence that's going to make the defendant a better person. Right? Less likely to commit a crime again, but go forward and learn. So the juvenile defendant is defended by someone their own age, they're prosecuted by someone their own age, and they're sentenced by a true jury of their peers. It is a positive peer model that's throughout the country, and it's got amazing, amazing results. Because I can always do my teen court, or do my juvenile court. I sit as a criminal juvenile court judge. And if I say to somebody, they're only hearing this 59-year-old woman fussing at them. But if they hear another 15, 16, 17-year-old person say, nah, that's not how you do it. That's not the right way to do it. It has a bigger impact. So if you ever know of anybody that's interested, we run teen courts starting in August, September every year. I have been a teen court judge since 1996. So now I have lots of help. We run lots of cases. We're on track to hear about 85 cases this year, which is an incredible number. We have volunteer attorneys from the Bar Association, and we have support from our local Bar Association, Notre Kentucky Bar Association, to help pay for things like graduation and so forth. The students are sworn in as members of the Court of Justice. Oh, look at that.
All right, so when they come up from tab, Judge, will you give this to the winning team?
I will. Can I come down here?
Of course.
So I don't kill myself?
I didn't get word yet that they're on their way, but they should be here soon.
So let me come down. Stop. Let me get that thing out of here. Oh my God, it's gigantic.
Thanks.
Do you always get one of these? Yes. So how many of you won these? Any?
We won last year.
You won last year?
This is our first year
Is this your first year?
in the finals.
Oh, how many years have you been on the team?
She's been on it since the beginning. This is 4 years.
You all did. This thing's really heavy. Can you imagine the damage I can do with this? It's very heavy. It's very beautiful, actually. That's really cool. I have a friend of mine who made me actually one of these. It's a little shorter, but it's just as big. It's sitting in my office. So, do you have any questions about anything I said or did or how I ruled or?
Did I make you too crazy?
No, I thought the rulings were very fair and you explained them very well.
Yeah.
I was like very understanding after you explained them, like, oh, okay, that makes sense.
Yeah, that's the teacher in me.
Yeah, sometimes I get judges that doesn't explain it, I'm like, oh, okay.
And you just have to move on. Yeah, well, and that's reality, right? Some judges like to yammer, me. And other judges are very quiet and they just want to move on. So you're going to get all kinds of different people. And I'm sure when you, does the winning team go to the Nationals?
Yes.
We're nationals.
Athens, Georgia.
I love Georgia. I was able to be a judge in the 1 year at the Nationals in North Carolina, which was really a cool experience. So I hope you all get to go. Oh, are you guys ready yet? We're ready. Come on in. I stand here with your gift.
Oh, perfect. There we go. All right, teams. By a difference of 2.5 ballots to 1.5 ballot, the team who is going to be going to nationals and is the Kentucky State champion is Notre Dame.